Good
Thank
morning,
you.
JCJ.
Good morning, Chief Justice, and thank you for the indulgence while I was arranging my affairs.
Well, I understand completely what one has to do when one sits in that chair.
Yes.
I've been there many times.
Yeah.
How are you this morning?
I'm fine, Chief Justice, as fine as can be. I must confess I'm exhausted. It's been a grueling term, and I think I can
Yeah,
safely say that no one in the Constitutional Court has enjoyed a good night's sleep in the past 3 weeks.
yes,
But
yes, yes. No,
business
no,
has to go on.
no. That's true. This term has been very, very bad. There have been urgent
Yeah.
electoral matters which came on top of the big workload that we have
Yeah.
anyway.
Yes.
And and in regard to the electoral matters and some of the matters, I've left things to you to lead.
Thanks for that opportunity. I hope I didn't let you down.
No, you have not. I thought maybe you are going to complain that I
No,
left too much to
never.
you. uh, Thank you very much, DCJ, for uh, accepting the nomination, your nomination by the President for the position of Chief Justice. We are gathered here pursuant to the letter that came from the President addressed to me, in which he indicated that he was contemplating appointing you as Chief Justice and requested to have the benefit of the views of this commission on your suitability for appointment to that position. And that letter then triggered the process that has led us to today. So, therefore, our task today is to interact with you, interview you, with a view to enabling ourselves to express a view to the President on the issue that he asked us to express a view on, namely your suitability for the position of Chief Justice. I'm not going to explain how this body works because you know it very well. You have checked it and you know very well. So I think that we should start immediately, but relax. In the way in which we will do the interview, we will afford you an opportunity and give you about 30 minutes that you can use to share with the Commission your vision for the judiciary, and we will also be able to ask you questions on various issues relevant to the position of Chief Justice. I do not think that it's going to be necessary to traverse your background that is so well known, not only to this body, but I think nationally, because you were before this body not so long ago. I think that it will be important, it will be necessary to accept that certainly all the members of the commission are very familiar with your background because it's in the bundle, but also in the past 24 months, I think you've appeared twice and shared that background with them. So I think that it would be important to go straight to the important issues. I will just mention that that background does include that you hold a BProc, LLB, and NLM degrees, and you got your BProc at the University of Transkei, you got your LLB at the University of Natal, you got your LLM at Duke University in the USA. You practiced as an advocate for a number of years. You were a judge in the High Court for a number of years. You acted in the Labor Court. You became a judge in the Supreme Court of Appeal. You rose to be Deputy President of the Supreme Court of Appeal, ultimately becoming President of the Supreme Court of Appeal. You are currently the Deputy Chief Justice of the Republic, and you have delivered many papers on legal subjects as reflected in the bundle, and you have held many positions of leadership in certain organizations, including the South African chapter of the International Organization of Women Judges. Is anything that I've said so far not true?
No, everything is corrected. I must say I'm impressed that you seem to know so much about me. You barely looked at your notes.
Yeah, no, I think I do. We have known each other for a long time. So I'm going to therefore start my questions when you joined the Constitutional Court. That was in September 2022, is that correct?
Yes, Chief Justice, time flies. Almost 2 years ago now.
Yeah. Would you like to share with the commissioners what your experience was when you joined the Constitutional Court in September 2022, how you were received, how the spirit was, and then, of course, you can talk about how you found the work to be over the past 1.5 years or so.
Thank you, Chief Justice. Being appointed to that court, even if I had not been appointed in a leadership position, has to be it's the highest honor for someone in our line of business. That's where I want to think everybody would want to end up before they retire. So it was the biggest moment of my life to be appointed to that court, especially in a leadership position. And I must confess that it filled me with trepidation. The job of Deputy Chief Justice, whilst I have you to hide behind, is still one of enormous responsibility. So I went there with the full awareness that you would be delegating important responsibilities to me, and I worried a bit about that. But once I got there, I had forgotten just how collegial that court is, because I had been there many years ago when we were still, we both acted, I think it was in 2012. And I found a similar environment. A group of collegial, very warm colleagues who were willing to, it's an open door policy there. Everybody was willing to give me, their precious time to to orientate me, answer any questions I may have, and just make me feel comfortable. So I was very warmly received, and I appreciated that. I came from the Supreme Court of Appeal. The last time I had been at the Constitutional Court, things were not as hectic. They were nowhere near as hectic as they are now. So I did not really have any idea what to expect. We, as spectators, we always said, bragged that the Supreme Court of Appeal is the highest working court in the country, and it's still able to produce results in lightning speed turnarounds. But I was in for a rude awakening. I have not worked as hard in my entire life than I have in the last 20 months. That court is extremely, extremely busy. I will get to that. Part of the reason why we hardly have time to breathe actually has a lot to do with the manner in which we work. I'm trying to find tactful language. So I do believe that there are a few things we could tweak to streamline our operations and give ourselves more time, just to breathe. So that's the kind of court I found. Very hardworking, which people don't know. We are judged. It's said we receive no more than 400 new applications for leave to appeal, for example, in a whole year. And we don't set down more than 40 matters for hearing, and we are compared with the Supreme Court of Appeal. But those numbers are huge when you consider the fact that we sit and bank, and just the way of working there is different. And there's the added responsibility, the added weight that our word is the last in all the matters we determine. So we have to pay particular attention to every matter that comes before us before we issue a decision. So that's the best way I can describe it. But the work, bar the constant fatigue and just sometimes one can feel overwhelmed, especially when you're in a leadership position, and in addition to the core judicial functions, you have all these other administrative responsibilities to take care of. It does happen that sometimes that you feel, oh, I wish I had stayed in the High Court and just remained a judge where I could only worry about going to court, listening to counsel, argue their cases, and go and write my nice judgments. So one does not have that luxury. But I would like to think that I've coped with the cooperation and support of colleagues, and more especially you, Chief Justice. I do want to give you that credit while I sit here and many people in our country are listening. You've been such a huge support to me. You've exposed me to all the work that you could possibly do, and we're always there in the background. Even if you allocated me a task, I always knew that you would be there, to make sure that I'm on the right path and I'm okay. So that is the Constitutional Court I've experienced. Work is exhilarating, of course. I love the intellectual bits, but it's extremely hard. I have to say that.
So, the actual work you say you enjoy, it's just that
I enjoy it.
the volumes are huge.
They are huge.
Yes, yes.
Too huge.
Yes. During this 20 months, period of 20 months or so, have you been given an opportunity to preside in matters? Do you want to share your experiences with the
Yes.
commissioners about sitting and presiding in matters in the absence of the Chief Justice?
I have done that, Chief Justice, on a number of occasions, but well, there was nothing new there. Presiding in matters begin in the High Court, where you don't even have the support of the colleagues around you. You are sitting alone and have to, to deal with everything all on your own. So that has not been the most difficult part of the job. But I've done that, and it has gone well.
Yes, no, I've no doubt it has gone very well. But of course, the difference between whatever presiding you may have done in other courts and doing it in the Constitutional Court is that this is the apex court, number one. Number two, you are presiding in a court where you are not sitting with two other colleagues or four other colleagues, you are sitting with 9, 10 others, and managing that might not be the same as managing four other colleagues or two other colleagues, isn't it?
That is indeed true, Chief Justice. No, the stakes are highest there. You are managing many more colleagues who have, I'm not saying that the others where I came from did not have strong opinions, but there's always that added pressure underlying everything that this is the apex court. So whatever word we utter must be weighted in gold, and you have to manage all that.
Yes.
Yeah.
Yes.
And of course, the prize possession for any court is to get judgments in which everybody agrees, so that the court speaks with one voice. But of course, that's not always possible. And in any event, it has. We know the saying that today's dissent may be today's majority. So I'm not saying dissent are a bad thing, but just being able to manage, because more often than not, when you go into court, there are divergent views, and if the panel is able to, to converge at a common point and be able to speak with one voice, then that always fills one with, with a gratifying sense. So.
And did you find that sitting with so many colleagues had an impact on how long it took sometimes to have final conclusion on a matter in terms of judgments? Because there might be so many different views and persuading one another might take time.
Of course, naturally, and I want to stress that this is not a phenomenon that's peculiar to our apex court, because it is an apex court and there are so many views to accommodate. Judgments are always going to take time to come out, and we just had the Canadian Judicial Exchange recently, where we were comparing notes with our counterparts from over there, and we did an evaluation of our operations, and it came out that on average our judgments may take as many as 6 to 8 months to be finalized, because there's back and forth. It's a whole process, and it may even be longer. It may take longer where there are many. The divergence, of views persists, and there are going to be many judgments. You can't hurry judgments of the apex court. Of course, we have a responsibility to get our judgments out expeditiously, but because it's an apex court, we have to take extra care, because once it is out there, there is no opportunity for a litigant who is unhappy with the result to appeal somewhere. It ends with us. So that is a complicating factor.
And during this period, have you been given an opportunity to attend heads of court meetings and to be part of discussions of issues at that forum?
Yes, Chief Justice. I have attended, well, almost all, if not all, the heads of court meetings that have been called in recent times, and was part of the deliberations and decisions taken there. And not only have I been part of heads of court meetings, you've given me an opportunity to sit in other structures. For example, I have attended the NEEC, the National Efficiency Enhancement Committee meetings, one with you and the other one I chaired, and I have chaired such council meetings in your absence, and this body's sittings on occasion. So I have had an opportunity to participate in all those spheres of our job, and sometimes in your absence led the proceedings.
So you have presided in matters in the Constitutional Court. You have attended meetings of the NEEC with me, and you have had an opportunity of chairing the NEEC on your own in my absence.
Yes.
You have also chaired a number of interviews of this body as well. Is that correct?
Yes, Chief Justice.
And all of those are some of the functions of the Chief Justice. Is that correct?
Indeed.
Yes. And you chair the EXCO of the Sajay Council as well, is it?
I chair the EXCO, the Executive Committee of the SAJA. I chair its Finance and Budget Committee as well. And I may mention that I chair the Judicial Accountability Committee of the Heads of Court.
Yes.
In addition to that, so I've been lucky. I've had an opportunity to be involved in the leadership structures of the judiciary.
Yes.
In all the leadership structures of the judiciary,
Yes.
actually.
And of course, also you were given the responsibility of being acting chair of the Judicial Conduct Committee, and therefore basically run the Judicial Conduct Committee. Is that correct?
That is so, Chief Justice.
Yes. I'm sure later on there'll be a chance to talk more about the work of the Judicial Conduct Committee, but I just
Yes.
thought let's touch on those matters where it's part of the function of the Chief Justice, and you have already had the chance to do those without any problem. Okay. At this stage then, DCJ, I'm going to give you an opportunity, 30 minutes, but if you finish earlier, that's fine, to share with the Commission whatever vision you have for the judiciary, so that if you are appointed, that's the vision you want to pursue.
Thank you, Chief Justice. May I ask an indulgence? I've prepared a timed written statement, because if I just talk, if I ad lib, I may not finish what I tend to ramble. I may not finish what I want to say and be concise. Is that all right?
Do you want to read it, or you want to share copies? What do you
No,
want?
I only have a copy.
Oh,
for
you want to
myself.
read it?
Yeah, I just
That's
like to
fine.
read, but I have an electronic copy
Okay.
if the commissioners want me to share it with them.
No, that's fine. I think if there is a copy and you are happy to give it to the Secretariat for them to make copies for us, that can be done while you continue. The Secretariat will make contact with you.
Yes.
But if you say, no, I don't want them to look at paper, I want them to look at me as I present this, we will abide.
That actually is a good idea. I'd prefer it if you looked at me.
Oh, okay, all right.
Thank you.
Okay, all right. So Secretariat, don't take it. Okay.
Thank you, Justice. May I go ahead?
We are all ears, yes.
All right.
All eyes.
Okay. Before I set out the vision I have for the judiciary, I want to explain first how I understand the role of Chief Justice and the nature of the duties that attach to the position. Section 165, subsection 6 of the Constitution and Section 8 of the Superior Courts Act, which are not exhaustive, broadly state that the Chief Justice is the head of the judiciary and exercises responsibility over the establishment and monitoring of norms and standards for the exercise of judicial functions of all courts. In real terms, the Chief Justice holds a multifaceted, complex role, as may have already come out from the brief exchange we just had, Chief Justice, and leads a massive judicial system comprising a multi-tiered institution which starts from the apex court and runs all the way down to the lowest rank of the hierarchy set out in Section 166 of the Constitution. But there is a strong support network around the Chief Justice, which is provided by the Office of the Chief Justice, the national department established to render support to the judiciary, to ensure effective and efficient court administration services. Then there are the heads of court and the judges and magistrates themselves, who are highly educated and experienced professionals. The primary function of a Chief Justice, which is shared equally with all other judges, is to adjudicate the cases that come before the Constitutional Court. That is, her first duty is to sit in court and produce judgments and produce those judgments expeditiously. And her vote in the adjudication of cases carries the same weight as those of her colleagues, to whom I may mention she is only first among equals. Then follows the additional, numerous, and unique responsibilities that attach to the position. The Chief Justice is responsible for the administration of the apex court and exercises final authority of the functioning and management of all courts. So in the Constitutional Court, she will perform the usual duties of a head of court, which include allocating cases and other judicial duties to the judges, determine sitting schedules, manage procedure to be followed, and issue directives in respect thereof, case flow management, overseeing the expeditious finalization of matters, setting recesses, and so on. On the bigger stage, there is a long list of responsibilities which entails the oversight of all the courts and the Office of the Chief Justice, setting norms and standards for all courts, chairing various judicial institutions such as this body, the Judicial Conduct Committee, and the South African Judicial Education Institute, attending the appointment of office bearers who are not judicial officers, chairing the panel that furnishes candidates to the National Assembly for appointment to the Electoral Commission, designating members of the Judicial Conduct Committee, determining the budget for the administration and functioning of the superior courts, swearing in various public officials, representing the South African judiciary on regional and international judicial organizations, such as the J20 Chief Justices Forum, from which you just returned, Chief Justice, the Southern African Chief Justices Forum, the Conference of the Constitutional Jurisdictions of Africa, and others, attending the periodic review of the Judicial Code of Conduct, and many other responsibilities. In sum, the Chief Justice is the face of the institution, the judiciary. As I said during my last interview, our country has suffered a lot of upheavals in recent times and faces many serious challenges. So the need for an impartial, independent, effective, accountable, responsive, and cohesive judiciary has never been greater. If I'm appointed for this position, I know that I will bear the enormous responsibility of ensuring that the institution remains strong, retains its integrity, and firmly executes its role of protecting and promoting the Constitution and the law, so that our country, especially the poor and most vulnerable members of our society, are guaranteed access to justice. As I understand it, and I have seen that this is the public expectation, this position requires someone who will inspire stability and cohesion within the judiciary itself and inspire public confidence in the judiciary. And I believe that I can do that. Fortunately, despite all the challenges in society and within the judiciary itself, there is an efficient system of judicial administration in place, which the public still respects. But there is a lot of work to be done to get the institution working optimally to execute its constitutional mandate. Before I present my actual vision, I ask to preface my statement with a qualification that while it contains, that is the statement contains my wish list for the judiciary, a judiciary that is contemplated in Chapter 8 of our Constitution, which vests judicial authority in the courts, and envisages a judiciary that is independent, impartial, dignified, accessible, and effective. This vision is not solely mine. It draws significantly from discussions and resolutions of the judges and magistrates flowing from a meeting of the judiciary that was held a few months ago in December 2023, with the aim of reflecting upon and reviewing the challenges facing the judiciary and determining how the accessibility and effectiveness of the courts can be enhanced so that South Africa may have a single judiciary with a fully integrated system, structures, and leadership of its own, a judiciary that is effective and fully independent from other arms of government, a judiciary that runs its affairs independently and is accountable only to the Constitution and the law. I may just mention that this meeting we had in December 2023 is the one I had proposed in my vision to this commission when I was interviewed for this position in 2022, because judges and magistrates had been clamoring for a judicial lekgotla since the last one that was held in July 2011. And this arose from the fact that there had been a number of important developments in the institution. And thankfully, Chief Justice, you heard the cry and saw the need to have that kind of meeting, and you arranged the platform which provided the institution with a critical barometer. From that meeting, the judiciary came out with a clear picture of its achievements since democracy and its current needs, challenges, weaknesses, and most importantly, whether it is fulfilling its constitutional role in present-day South Africa. But even after that meeting, I have continued to consult various colleagues, both senior and junior, who may not have had an opportunity in the meeting to speak on the burning issues or have since had fresh views. And this was to ensure that I have widest and as many perspectives on issues as practically possible. So I can safely say that this statement encapsulates the judiciary's own vision for itself, a vision I intend to help execute during the rest of my tenure as a judge, whether I am appointed to this position or not. I also want to confess, Chief Justice, you may have got a sense of this from our earlier conversation. I want to confess that the candidate you see before you today is very different from the one you interviewed in 2022. Then I was buoyed by the optimism, energy, and perhaps a touch of innocence of a younger self coming from a small, albeit very important and senior, fairly easy to manage and very efficient Supreme Court of Appeal, which has had the systems that make it run so well for many years. That was 20 months ago, and the person who sits in front of you today is older and seasoned, I might say. So, in the time I've been in the Constitutional Court, I've gained valuable experience, such as we covered during the introductory part, Chief Justice. I've had an opportunity to get a taste of what this job actually entails. And I must say that it has been a sobering experience. And I remember, I'm going to disclose a chat you and I had a few days ago where I was saying there is absolutely nothing attractive about your job, Chief Justice. If I had a way, I would go and hide in a hole somewhere. I'm not sure I want it. It's too hard. So perhaps I should just expatiate a little bit on these things that I have been doing. No, there's no need. We covered everything, except that I just like to explain a little bit of what the Judicial Accountability Committee does, because it does important work. It helps facilitate the judiciary's annual reports and keeps an eye on the implementation of the judiciary's performance assessment tools, among other tasks, of course. And importantly, it's responsible for one of the accounting tools of the judiciary to the public, which is Judiciary Day. It is that committee that arranges that event. I may just mention that in the work I have done in the Judicial Conduct Committee, I have been able to prepare and submit to you a performance report just for the last year, which sets out what it's just a bird's eye view on what the committee has been doing, how it has fared, and I recently gave it to you for consideration. Well, I have said I have experienced I've dipped my feet in the water, and I have found out that this job is difficult, to say the least. But I am confident now more than ever that I can do it with the support, of course, of my colleagues and smart management. And we have many colleagues. At last count, I think we are 252. So I would have 251 people on the upper ranks of the judiciary, and just under 2,000 in the lower ranks in the magistracy, when they are finally brought into the fold to assist. And as I said earlier, all these colleagues have long experience and valuable insights, which I have no doubt I would be able to harness, because I am a strong proponent of inclusive and collaborative leadership. And I know that I have the soft skills to make everyone feel that they have a stake in this institution, and that we all share the responsibility to make it work and deliver on its constitutional mandate. Back to the deliberations of December, that meeting threw into sharp relief the adverse consequences of its lack of institutional independence first. Independence, which would include operational and financial autonomy. And we saw starkly the negative impact this has on the judiciary's effectiveness and efficacy. So the judiciary reaffirmed its quest for a judiciary-led court administration model, as it aligns closest to the notion of judicial independence and will enhance administrative and the administrative and financial efficiency of the courts. The meeting also identified the challenges and weaknesses in the operations of the judiciary that impede its achievement of optimal effectiveness, efficacy, and independence, and results, amongst others, in the delay of delivering judgments and finalizing cases. And these included shortages of judges themselves and staff, infrastructural challenges in court buildings, the slow rollout and implementation of court modernization, in particular, information communication technology and digitization, the undue delays in promulgating legislation for the implementation of court-annexed mediation, which has been established, would be beneficial for litigants and the administration of justice, as it allows expeditious resolution of disputes, identified as well the weaknesses in the system of accountability and transparency in respect of the conduct of judicial officers and the undue delays in dealing with complaints against them, which may erode public confidence in the judiciary. Those undue delays referring to this body. The significant reduction over the years of judicial officers' salaries as a result of the failure to grant increases that are at least in line with inflation, and the need for a specialized framework as contemplated by the Constitution for the proper determination of the salaries and benefits of members of the judiciary, and the safety and well-being of judicial officers, which are all matters of great concern, requiring ongoing assessment and measures of intervention, which we have not received. The judiciary then made the following resolutions. First, to urgently take all steps necessary to establish a single judiciary, including the migration of the regional magistrates and magistrates' courts to the office of the Chief Justice, as was intended when the decision to achieve institutional independence for the judiciary was taken in 2013. The establishment of the office of the Chief Justice that year being merely the first step of that process. And it was noted that this will entail that all the functions relating to the judiciary and the operations of the courts that remain within the Department of Justice and Constitutional Development shall be transferred to the Office of the Chief Justice with the autonomy of its own budget and necessary human resources. And these functions, it is important to state them, include the security management functions for all the security needs of the judiciary, the courts, library services, and the procurement of books, journals, and other related resources, ICT services, including the procurement of ICT resources, the rules board, which makes rules for the courts, but is not part of us really, and the infrastructure and facilities, and all procurement of such facilities that is required by the judiciary. Importantly, in relation to infrastructure projects, the OCJ in that dispensation would be able to deal directly with the Department of Public Works and Infrastructure instead of having to go through the Department of Justice, which has problems of its own. I'll get to those a little later. The second resolution was to intensify the efforts of the leadership of the judiciary to finalize the issue of full institutional independence of the executive. Such full institutional independence to include a judiciary-led court administration model, financial autonomy, and operational independence, as was mentioned above. In this regard, the Chief Justice issued a statement, and just for good effect, I will repeat what that statement said. The judiciary expressed its deep disappointment that for over a decade, the executive has failed to respond to its proposals for a judiciary-led court administration model. And the executive was urged to give the matter urgent attention so that the transition to a fully independent judiciary, which is on the same level with the other two arms of government, is achieved, and the principle of judicial independence is entrenched. The third resolution was to assess the existing ICT system and identify the necessary system upgrades and required ICT infrastructure resources of the courts, importantly inclusive of the lower courts, expeditiously. To expedite, the fourth one, the implementation of the national rollout plan of the court online system to the Supreme Court of Appeal and the Constitutional Court, and ultimately all the superior courts. The fifth one, to urge the relevant role players and stakeholders, including the South African Law Reform Commission, to urgently take all reasonable steps to implement court-based mediation and alternative dispute resolution systems. 6, to assess whether the Judicial Service Commission Act may be amended to streamline disciplinary processes and expand the composition of the Judicial Conduct Committee, designate more retired judges as members of the committee, and to consider the application of these changes to the legislation governing complaints against magistrates as well. The seventh resolution was to task the Chief Justice to initiate a review of the Judicial Code of Conduct regarding the timeframes for delivery of judgments, which would take into account the special circumstances of appellate courts as they sit in panels and thus take longer to finalize their judgments. The eighth one, another task was another task given to the Chief Justice to ensure compliance with Section 12, subsection 4 of the Judicial Service Commission Act, which requires the Judicial Code of Conduct to be reviewed every 3 years and to initiate a review of the norms and standards for the performance of the judicial functions to ensure that the stipulated timeframes for the delivery of judgments are realistic. The ninth one was to task the Chief Justice to initiate discussions with the executive with a view to the establishment of an independent body created by national legislation as envisaged by Section 219, subsection 5 of the Constitution, a body that will determine the salaries, allowances, and benefits of judicial officers to replace the independent commission for the remuneration of public office bearers that is in place now. There were other tasks assigned to the Chief Justice relating to, for example, deceased judges' benefits, judges' pensions, and their medical aid scheme. And lastly, it was resolved not to allow what we had, the trap we had fallen into in recent times of not having meetings regularly. So it was resolved that every 2 to 3 years we would reconvene to review the status of the institution. Now, although it may have been a tedious exercise, I have tabulated these resolutions in painstaking detail because they constitute the agenda and timetable, which I fully support, by the way, that the judiciary has set for itself and expects the Chief Justice to execute. So I have a template. And the judiciary is not, I must say, the judiciary is not wasting any time in taking steps to ensure that these goals are achieved. And some of the work has already started or has been in progress for some time. And I'm happy to relay this through a project driven with great commitment and passion by Judge President Mlambo. The judiciary is finally on track to complete the rollout of case lines and court online to all superior courts by the end of this year, except for 2 high courts, I believe, which are temporarily housed in old buildings that cannot support the technology. But on the whole, the entire rank of superior courts will have this technology by the end of 2024. And it is hoped that the rollout will extend to the magistracy to enhance the efficiency of and access to those courts. Now, this one depends on Minister Lamola's department's approval of the project. And if by the time I am appointed, if I am appointed, that has not happened, that approval is not come, one of my first tasks would be to urge Minister Lamola's department to make that decision so that our lower courts are capacitated as well. On the Judicial Conduct Committee front, 3 retired judges have already been designated to the committee with immediate positive results, and the Chief Justice has already approached the executive about amending the Judicial Service Commission Act to expand the committee's capacity. There is also the pressing issue of the crippling budget cuts in the judiciary and legal sector, which are extremely detrimental to judicial operations and have arisen because, well, in the case of the judiciary, while the circular determining the state institutions to which the cuts apply purports to exclude the judiciary from its scope, the Office of the Chief Justice, which provides support to the judiciary, is inexplicably not excluded. But the Chief Justice has already requested a consultative process with the executive to look into that challenge. and that process must be seen to the end urgently. So this is the template I would adopt and see to it that its targets are realized. But I do have further ideas on where else and how to effect improvements in the institution, and I add the following list to the above template as my key priorities. Foremost, of course, is attaining full independence for the judiciary and bringing the magistracy within the fold of the Office of the Chief Justice. But these processes, understandably, will obviously not be finalized overnight, but they require immediate consultations are required between the judiciary and the executive, and urgent policy and legislative steps must be taken, and I would agitate for those. The rest of the issues that I will mention relate mainly to the capacitation of the judicial establishment. First, the Constitutional Court, along with the rest of the court, but I'm just focusing on the Constitutional Court for now. That court must be adequately capacitated to be able to perform optimally and deliver justice expeditiously. And this could be achieved in the short term if support systems such as those used by other apex courts in jurisdictions such as Canada, Croatia, Finland, Germany, Spain, and others are adopted. And these measures, for example, allow the apex court to have, in addition to law clerks, panels of experienced judges or experienced senior lawyers who assist with the sifting of the matters that are placed before the justices and the preparation of opinions on those matters so that the judges do not drown in ceaseless applications for leave to appeal, some which have no merit at all but must still be considered by 11 judges, as is happening now. This would free up precious time for the judges to write judgments and hand them down quicker than they are. But the long-term solution, which I understand Minister Lamola's department has accepted in principle, is the amendment of the Constitution, a process which must be started as soon as possible because it takes time. The aim of this amendment would be to allow the adjudication of applications for leave to appeal and even court hearing panels by a smaller number of judges, smaller panels as they have at the Supreme Court of Appeal to speed up the pace of work. That would make a huge positive difference. And if that happens, the other ideas to speed up the delivery of judgments in the court might perhaps not even be necessary. For example, I had in mind internal arrangements in the court, such as allowing post-hearing conferences of the style they use at the Supreme Court of Appeal to meet directly after a hearing, to allow all the judges, the panel, to express its views on the matter quickly so that everyone knows where they stand early on and can start writing and not have to wait for responses to the scribe's post-hearing note, the post-hearing minute, as we have now, which may take a while because colleagues are swamped by other pressing work. The court could set strict timeframes for the progress of the judgment writing, which the collective would strictly monitor. I suspect that the chairperson might not approve this idea, but I would also advocate for the appointment of more judges in the court so that the work is spread wider among more judges. As I understand it, the court can accommodate as many as 15 judges now, and creating these extra positions would, in my view, fit with the idea of allowing smaller panels to adjudicate applications and appeals and ease the pressure on the judges. Secondly, the whole country knows that the caseload has increased, litigation has exploded, it has increased exponentially over the years across all the courts. Courts which are understaffed administratively, in terms of research capacity, and the number of judges in the superior courts, in the midst of all what has happened in recent times, the dramatic increase of work, the number of judges remain largely unchanged. So the same number of people who were dealing with much fewer cases a few years ago have to manage with impossible caseloads. Judges are struggling tremendously to get all the work done at the risk of their health and well-being. And I dare say, because this is a hotly contested issue, when they are not even paid properly for their effort, as a result of the budget cuts, it is no longer possible to appoint acting judges to assist with backlogs. And this is a tussle I had with Minister Lamola when I was still at the SCA. Because there is no money, Treasury said there is no money, and we sit with all this work, and when the judiciary is not able to deliver on its constitutional mandate, fully, the public will point fingers at it that it's not doing nearly enough. More judges and administrative staff and enough law researchers must be appointed in these courts to alleviate pressure on the existing judges and reduce the incidence of delayed judgments and avoid the delays in dispensing justice. I was just having a chat with President Molemela recently about the capacitation of her court. And I was horrified to hear that the Supreme Court of Appeal, a senior court, a very important court, where most of our cases end, because it's just a fraction of cases that go to the Constitutional Court. Many cases end there. That court only has 3 researchers shared among 25 judges, and that is totally unacceptable. It's a miracle that that court is still able to perform as well as it does with such constraints. And I'm sure the strain on the judges, is unimaginable, and that should not happen. People should not have to sacrifice their health for work when there are measures that can be taken.
May I just interrupt you briefly to say we have gone over the 30 minutes, but you can indicate if I should give you, 10 minutes more?
Just 10 minutes will do, Chief Justice.
Okay,
Thank you so much for the indulgence.
Okay, all right.
Thirdly, I want to touch upon a notorious fact that there are serious challenges of poorly maintained infrastructure that is falling apart in all the courts, as Commissioner Makwanishe and his portfolio committee can attest, all the way from the Constitutional Court, which has a leaking roof, cracked walls, outdated ICT and security systems with broken biometric X-ray machines, which have been in a state of disrepair for a few years now, which compromises security in the court. The present system requiring the OCJ to communicate with the Department of Public Works, which is in turn notoriously unresponsive, we all know that, to attend these matters, stymies any effort to address these issues and has to be addressed urgently while the judiciary waits for institutional independence. The progress that has been achieved with the transformation project is not enough, and gender diversity still needs attention. So while the OCJ is to be commended for the aspirant women judges program that was recently resuscitated from the days of former Minister Mabandla, it's a very useful tool in this regard, but it needs to be intensified, and that project itself is already at risk because of budgetary constraints. This body is doing well. The focus has been on the JSC for many years, and we know the reasons. The body is doing well insofar as its judicial interview processes are concerned, having reviewed its processes in recent times, and there are barely any complaints about its procedure lately. But its operations must be strengthened where necessary to ensure the speedy resolution of its disciplinary processes. The issue of acting judicial appointments, which some interested parties have complained are processed in secrecy, remains a point of contention and needs to be revisited between the heads of court, the JSC, and the Minister of Justice. The judiciary needs a properly functioning communication structure that conforms to the institution's communications policy and properly deals with issues affecting the judiciary, and a spokesperson who will represent the institution when the need arises, which is often. We have not had a spokesperson since the departure of the last one. I think it's been a few years now. And on occasion, I've found myself having to cobble statements with the Secretary General, and that's totally inappropriate. I have proposed during my previous interview a structure that resembles what they have in the UK Supreme Court, for example, a communications department which includes a judge, perhaps a retired one in our case, who has an understanding of the law and can address legal issues properly where necessary. The loss of public confidence in the judiciary is another worrying feature. We hear about the expert survey results, which are not favorable to us, and that does not augur well for the rule of law and our democracy. My view is that the judiciary cannot leave this matter in the hands of other stakeholders and needs to do something itself. And we can start by the manner in which litigants are treated in our courts, how their cases are adjudicated, and the speedy finalization of their matters, and the production of reasoned court decisions, which will explain to the parties how a court reached its decision. The judiciary has a communications policy, which is meant for use to demonstrate a number of things, including the judiciary's efficiencies, court operations, its role, and so on, and educate the public. And I don't think the judiciary has used that tool optimally. And I have in mind, and I can flesh this out during questioning, I have in mind outreach programs in addition to what is done now through the judiciary, of course, speaks through its judgments, and courts, at least the senior courts, do issue media summaries and tries to inform the public about their judgments. But not all courts can do that. More is needed, and the communications department with the judge could be used to conduct outreach programs and engage the public to find out why this confidence is declining, so that communities can understand, for example, why a perpetrator of crime is arrested and then is granted bail, and he was arrested yesterday, tomorrow he's back in the community. Processes that can explain court judgments, which are usually misunderstood, and then you have influential people who sometimes will come out in public and criticize the judgments harshly, and when it's obvious that the person has actually not even read the judgments, and those kinds of things can only have a detrimental effect on the confidence of the public in the institution. Explain the Constitution and the rights it protects, the difference between the courts and the other arms of government, and so on. I'm just going to touch briefly on this. I still have 4 left, Chief Justice. The NEEC needs to be revitalized. In recent times, it has become noticeable that not all the stakeholders are as committed to it, are participating as they should, and it is a very valuable tool to enhance the performance and outcomes in the delivery of justice. So we can't let it wallow. Then there's the safety of our court buildings and court personnel, which must be prioritized. Our courts are not safe. And I can just mention that JP Mlambo himself has been a victim of crime in the precincts of his own court. And there are many, many such stories of judicial officers who have been attacked in the courts of law where one is supposed to be safest. The judiciary needs to finally establish a functional judges' wellness program. And this is one thing that the magistrates have got right. They have a fully functioning wellness program. This initiative was conceived and developed during former Chief Justice Mukweng's time. It needs to be revived. It has stalled, it needs to be revived and implemented. Then there are the judges' conditions of employment, which must be improved so that the institution can attract suitable candidates to its ranks and boost morale, which is flagging. We know that the magistrates have recently been threatening to go on strike, and Minister Lamola knows all about that. We do not want such incidents. There are other problems with the rules board that is not able to function optimally because of the rules, the budget cuts, the judicial conduct committee that is struggling under the weight of the work, because the work of the Judicial Service Commission has also increased dramatically. In the JSC, the committee used to hear maybe 6 complaints against judges per year. Now it's that number every day, and there is a flood of complaints against judges that are coming in. And the secretariat has not only to deal with the processing of those complaints, they offer support to the Judicial Service Commission itself. They help with the operations of the judicial conduct tribunals. So the work is just too much for them, and they are not coping. There as well, there are posts that could be filled. They cannot be filled because of the DPSA, which operates in a way that when a vacancy arises, you have to seek the permission from Treasury, and we go back to the story that there is no money. One last thing, Chief Justice, there is an old perennial complaint, goes back many years, that the Chief Justice never visits the courts. I'm one of the judges who used to complain about that. And what I would try to achieve in the 10 years I still have left as a sitting judge, if appointed, would be to make sure that I visit each and every one of the courts in the country for the obvious benefits that would bring. In sum, Chief Justice, the resolution of many of these challenges lies in the hands of the executive. The judiciary cannot achieve what it seeks for itself without the cooperation and assistance of the executive and even the legislature to some extent. So the other thing that would be important would be to foster, to intensify the relationship between the leadership of the arms. I know that you have meetings with the relevant parties. I think more fire needs to be added there to make sure that the results that the judiciary wants are achieved from those interactions. I've had to scrunch up my key priorities, but that's about it. I hope I'll get an opportunity to flesh out some of the issues during questioning. Thank you, Chief Justice.
Yes, no, I've no doubt there will be lots of questions, DCJ, so you will be able to deal with some of the issues further. We are at 23 minutes past 11. Can we agree what time we should break for tea, so that I see whether we break now or we continue and break later? What is everybody's feeling? Shall we break later at 12?
We might as well break for lunch if we're breaking at 12. So I think the option is to break now.
Yeah, either break now or break
Yes.
12 at 12. We break now.
Yes.
Oh, okay, all right. Let's take a break.
Does the candidate get a say, Chief Justice?
Let's take a break now. We are going to return at 22:12. It's 15 minutes. Thank you. Thank you very much. We will now proceed. Thank you very much, DCJ, for the input that you have made. We will then put questions to you now. Let me start. Let's start with the Constitutional Court. And the questions that will be asked, you might find that you did deal with them in one way or another as you were articulating your vision, but it's necessary to have more focus on certain issues now. As far as the Constitutional Court is concerned, the complaints are usually that the new applications take too long to be disposed of, number one. Number two, the judgments are also, they also get delayed. And some people complain that the quality of the judgments is also needs attention. With regard to the delay in disposing of new applications and as well as the delay in the handing down of judgments, the reasons for that have been articulated, and there have been discussions among ourselves, and there were certain proposals. Now, I just want you to clarify whether, when you talked about panels, you were talking about panels in the same way that we all discussed, namely panels that would deal with new applications, but would not sit to hear matters in court, because the hearing of matters in court would still be done en banc, or whether what you are proposing is different, namely, even the hearings should be by panels, and therefore the en banc arrangement should be done away with, and of course it can only be done away with if there is a constitutional amendment.
Thank you, Chief Justice. I meant to cover both new applications for leave to appeal and appeals proper in this dispensation I propose of dealing with them in smaller panels. As we have discussed in the court, the smaller panels we envisage for the petition, the applications for leave to appeal would be panels of 3. A setup that's not dissimilar to what they have at the SCA, but there it's only 2 per panel, and then if there's disagreement, you get the third person to break the impasse. But here we could just go ahead and settle for 3 panels of 3, and I envisage that there would be matters of national importance that maybe, even when that small panel has processed the application and made its determination, may still want the concurrence of the wider court, and that could be catered for as well. In relation to appeals proper, whilst all matters that come to our court are of utmost importance, but some are more important than others. And there are matters of important constitutional import and matters of, in terms of 167, matters of general importance, national importance. Those matters could still be heard en banc by the 11 initially contemplated. But I do think that there's a scope for having smaller panels dealing with matters that are not so important. We do get a run of the mill matters with this general jurisdiction. So we could use that option in the case hearings themselves. That is, in sum, what I have in mind.
Just so that I am sure I understand. In other words, are you saying your proposal departs to some extent from the proposal that the colleagues have agreed upon, in the sense that you would not confine panels to disposing of new applications without sitting in hearings as panels. You say they would dispose of new applications as panels, but there would be some matters where you would say panels should be allowed to hear those matters, and those matters should not be heard by the full 11 judges. But you say there are matters of national importance where you would say the full complement of 11 must then sit. Is my understanding correct?
Yes, Chief Justice.
Yes. Now, of course, I guess you would appreciate that what would be critical in that proposal would be who would decide which matter is of national importance and which one is not. And what do you have in mind in terms of who would make that decision?
This model we propose envisages a sifting, an experienced sifting panel at first base in the registrar's office. But then obviously the decision would not be made. So all the matters that come before the justices, before you, would be matters that are worthy of the court's attention. Then as to who makes the call, the kind of call you describe, I think it would be the Chief Justice in conjunction with the Court of Cause. It seems to me that that is a weighty decision to make, and it might still require the inputs of the 11 or 15 if I have my way, but the full court.
But isn't the problem if the issue of whether a matter is of national importance is going to still go to the full complement of 11? Will that not defeat the purpose of panels? Because what we are running away from when we say let there be panels who dispose of new applications, we're trying to run away from a situation where all 11 get involved in so many matters.
Not necessarily, Chief Justice. The initial panel of 3 who work who determine the application first, would be able to
make that judgment call.
To make that call. Yeah. But I don't think they should make it on their own. They can tell when a matter is of such importance, and then they could, as we do with the memoranda we circulate among ourselves, they could write to the full court and say we have this kind of matter and we think it should be heard en banc, or what do you think? I don't think that would take much of the bigger collective's time.
So the panel would take a view. If it takes a view that the matter is not of national importance, they would dispose of it.
Yes.
If they think it might be a matter of national importance, or if they think it is a matter of national importance, then they inform the rest of the colleagues by way of a memo or whatever to say there is this matter, we think it's of national importance. What's your view? Is that correct?
That is what I have in mind.
Yes. And but you also say panels could sit to hear certain matters as opposed to the court sitting always en banc?
Yes.
Okay. And the panels would be of 3?
No. I think for the court hearings, you could have, considering the importance of the court, it would be more than 3.
How many do you think?
Not less than 5.
Oh, okay,
Yes.
okay. In which case, then you would have 2 panels for purposes of hearings, at least, because out of 11 you could have 2, 5. That's 10.
Yes.
So there could be 2, but there would be some matters where you would say the full complement must sit.
Yes.
Yes. Okay. All right. The issue of the appointment of lawyers, experienced lawyers, to assist, that is something you are going along with. You also approve of that.
Certainly.
Yes.
It has been
yes.
proven to work in other
Yes,
jurisdictions.
yes. No, that's right. This issue of complaints about the quality, have you heard it? What do you think of it?
Sorry?
Of our judgments? This complaint about the quality of our judgments, have you heard it? Do you have views about it?
I have caught smatterings of that, Chief Justice, but I would not react to that unless it was raised pertinently.
Yeah.
And I don't think it has been raised pertinently with us in a proper fashion. I mean, that sounds like a subject of a major conference
Yeah.
with the relevant people.
Yes.
Yeah.
I take it what it means is, since you joined the court, you haven't seen anything in terms of the judgments not being of good quality that makes you uneasy.
That has not been my
That
experience,
has not
Chief
been your
Justice.
experience.
Yeah. But I'm only speaking for myself.
Yeah. Now, the NEEC is a very important body. You talked about it.
Yes.
You did say that there is a problem with regard to the certain stakeholders attending meetings of the NEEC. Other than that, what is your experience of the functioning of the NEEC? Have you found that it's functioning reasonably well, or are there other challenges that you are aware of?
Well, it is a very important committee, Chief Justice, because all the relevant stakeholders in this business of delivering justice are involved at the highest level. It's the leaders who participate there. So if there are problems in one area, for example, there's a hold up with getting out DNA results, for example, which is one of the main problems we've had in the criminal courts. It is easier to nudge the correct functionary to ensure that whatever is necessary to unlock the log jam there can attend to that promptly. As I indicated, there are, well, all the stakeholders that participate are very important, but there are some who are more important than others. For example, the police, the NPA. So you want those people to give their full attention to a structure of this kind, so that they get they get the inputs that must be got across, and the rest of the stakeholders can have a clear picture of what is happening in those areas, as well as they impact its own operations. So that's why I was saying some have shown flagging spirits, and they need to be brought in so that they work as efficiently as that committee, has a history of doing since it started.
Of course, in each province there is a PEEC,
Yes.
a Provincial Efficiency Enhancing Committee, which is responsible for the efficient operations of courts in each province. and each PEEC reports to the NEEC about its work. In terms of your understanding, how are the PEECs in the various provinces working?
The PECs are working very well. The judges president are responsible for them, and they crack the whip. Well, I'm just using that as a metaphor. They make sure that the committees are working as they should. So that's just one aspect that gives one comfort that at least at provincial level things are taken care of. But then ultimately the decisions are taken at NEC. The heads, the people who wield the necessary power are at the NEC. So you need their buy-in, their participation. But the PECs are working well by all reports.
You referred also to the Judicial Conduct Committee. Would you like to share with the Commission what your experience has been of running the Judicial Conduct Committee over the past 20 months or so, and what improvements have been made in the functioning of the Judicial Conduct Committee?
Thank you, Chief Justice. As I alluded in my broader statement, there's a lot of work there. The report is that previously there would be very few, if there were more than 5, there were many complaints against judges per annum, and now you get this influx of complaints daily. So there's a lot of work for the members of the committee, and even more work for the poor secretariat. There was the biggest problem earlier, and we are still trying to mop up the effects of that now, is that the committee has 6 members comprising the Chief Justice, the Deputy, and the 4. The 4 would be judges, sitting judges in their own divisions at the SCA, most of them busy judges who have their own core responsibilities as judges, in addition to this function now. And rulings, it just took too long to get rulings out, and understandably, when you have to choose between deciding a complaint, a JSC complaint, and finishing your judgment, you are going to choose the judgment. So this work gets left behind. So there was the committee had a lot of backlogs, and we came to the realization that the key problem was that the judges who were members of the committee just didn't have time to focus on that work. And the only answer available was to designate retired judges. And we were able to get 3 such colleagues late in August last year. And the change was instantaneous. The work output is fast. But it's a full-time job, and it has distracted me a lot because all these complaints come through me initially. I just Friday, I got a huge box, and I wanted to send you a photo of these complaints that I must wade through. And that's the kind of situation we are dealing with. So it's a huge headache for me, but having these retired judges to deal with the rest of the process when they are not summarily dismissed in terms of Section 15 of the JSC Act, because that they have no merit, that you know that you have a complement of people who are going to work on them quickly and efficiently. So, as I say, the committee's work output has improved dramatically in the last few months. and rulings are being produced quickly. But then we still need to capacitate the secretariat because they are struggling. They have to process these complaints before they must sift them, process them before they send them to the chairperson, and then the chairperson deals with them, decides to maybe allocate others to judges president in terms of an arrangement you created to ease the burden on the chairperson, giving the heads of court the permission to deal with those dealing with involving judges in their respective divisions. So the secretariat must sift them, send them to me, then I deal with them, I send them to the rest of the colleagues. I'm going to be involved in appeals down the line as well. And the secretariat is involved in all that process. So things sometimes they fall through the cracks, they get delayed. I just had a complaint come to my attention recently that had been lodged last year already, and the complainant was threatening to go to the media to report us. And because of the load in that office, I understand their situation. That matter, it didn't get the necessary attention promptly that it should have received. So you get problems such as those, and all that it needs to fix them is to capacitate that office because it plays a very key role in making sure that the committee works efficiently, ultimately. So that's my experience so far.
Of course, you do.
I don't know if you want me to talk about the proposals we are making to increase the capacity of the committee.
Yes, you can deal with it. You can deal with
All
it.
right, just in brief, flowing from the conference resolutions, we are exploring amending Section 8 of the Judicial Service Commission Act to allow the chairperson, the Chief Justice, to increase, to have a pool of designated members, from which we can draw as and when the need arises for matters that are to be dealt with in terms of Section 16 and 17. That is, those that have not been dismissed ab initio, they go for further processing, for appeals, for consideration by the chairperson or a member that the chairperson designates to see if there could be something more. If the matter needs to be referred to a JCT, for example, a Judicial Conduct Tribunal. So that amendment, which we hope will go through swiftly, will ease the burden. I think it will cure the problem, and work can flow. The complaints can be processed as quickly as they should be, because there'll be enough people to deal with them.
Yes. Well, we have talked about the functioning of the Constitutional Court. We have talked about the functioning of the NEEC. We have talked about the functioning of the PEEC. We have now talked about the functioning of the Judicial Conduct Committee. If you get appointed as Chief Justice, you will be the chairperson of this body, the Judicial Service Commission. Sometimes there are also complaints which are directed at this body as well as the Judicial Conduct Committee, maybe also at the Chief Justice, to say complaints against judges are taking too long. So the one part relates to what we have just spoken about now, but the other part relates to cases where judges against whom there are complaints go to court to challenge complaints or processes or decisions, with the result that it can take years before there is finality. The judiciary gets criticized for that. Is that criticism fair? And if there's anything you think as Chief Justice, you would be able to do with regard to such delays? What is it?
Whew, that's a tough one, Chief Justice. Let me just clarify first that the delays I attributed to the JCC only relate to the early stages of the processing of the complaint. Once a tribunal, well, in my experience, once a tribunal, for example, has been appointed, the work goes quickly. Unless I'm subject to correction, but I can't think of a single tribunal that delayed this work. And as you point out, most, if not all, these cases that have spent as long as 16 years in one instance were delayed because the judges involved exercised their legal rights. They wanted, they challenged the process every step of the way, as is their right. And I'm not entirely sure what this body can do in that case. No one has a right to stop someone who is fighting for their life to keep their job from exercising whatever legal options they may have from doing that. So it's a difficult one, and I don't think, that said, I don't think the criticism against this body is fair.
No, thank you. You are also the chairperson of EXCO of the SAJE Council. Share with the Commission how SAJE is functioning. Is it functioning well? And the work of EXCO, because obviously EXCO is overseeing the work of the management of SAJE.
The institute is working very hard, Chief Justice, and I think they deserve that compliment. That, by the way, is the institute that is responsible for the continuing education and training of judicial officers. They do a tremendous amount of work to achieve the goals of that project. The only problem that has arisen now, I can mention that as the scope of our work expands, they make sure to add training in respect of those areas of the law. For example, in the last session that they ran for judges, there was a presentation in respect of court-annexed mediation, which we are longing to start using in our courts. So they made sure that the presentation is made, their own part of the process has been done. So that process is being held back. I digress now. That process is being held back by the Law Reform Commission, because I believe legislation is necessary to carry it forward. And as I understand it, things are still at the stage of a white paper in that commission. So things have stalled. But the SAJE for the judiciary has kept its own speed and started training. I mean, we had very useful presentations at our conference in December as well. So judges are ready to implement this tool once it becomes available. So the SAJE, it keeps up with developments. But to go back to the problem I started raising, budget cuts. There's an influx. There's I think it's about over 250 new magistrates that are coming in now, for example, who need training. And the debate in the Finance and Budget Committee was, how to deal with that. Do you conduct it? Can the institute afford to run physical sessions, training sessions for this group, which is the ideal, or does it have to conduct hybrid presentations, sessions, or virtual, because there's no money. Then there's this admirable program that you launched not so long ago, the Aspirant Women Judges program, which helps with one of my issues, the slow pace of gender diversity, because it creates a pool, it prepares potential candidates to draw into the judiciary. Now, there's a problem with that project as well, because many of the candidates are practitioners, for example, people who, these are adult people who are talking about, who have their family obligations. And if you are going to leave your practice, for example, for a period of a month to undertake training, then it means you don't make money during that period. So a need for a stipend was identified. There is no money to provide for that stipend. So that means a lot of candidates we could have had access to and trained in this for this project will be discouraged from participating in it. So in sum, Chief Justice, the SAJA does its bit. It does.
Now, you touched during your articulation of your vision on the issue of the institutional independence of the judiciary and the issue of judiciary-led court administration model. Would you like to elaborate further for the commission and just maybe mention some of the features that should be there before we can say we have our full institutional independence, and what some of the features should be of this court-led, judiciary-led court administration model?
In simple terms, Chief Justice, the powers that currently vest in the powers and functions that currently vest in the Department of Justice now would be transferred to our national department, the Office of the Chief Justice. The full autonomy, budgets, everything it takes to run a national department would be taken from where it resides currently to the judiciary. That is the simple explanation, along with the magistrates who we want to be absorbed in the judiciary.
When you were interviewed for the position of both Chief Justice and Deputy Chief Justice, I think you referred to the need for a sexual harassment policy within the judiciary. I prefer to say anti-sexual harassment policy. Would you like to update the commissioners as to where we are with that project?
Yes, certainly, Chief Justice. The project continues, and one hopes it's close to finalization. We had presented the subcommittee that was appointed that was tasked to prepare this document, submitted a first draft, which had to go through, it had to be considered by you, the heads of court, and certain points were made on its comments, and it was sent back to the subcommittee to consider certain aspects that it was felt were not adequately covered. So that process was finally completed just recently, and I think it's not more than a week ago that the second draft was submitted to you for further consideration. So it is hoped that the latest draft will be found adequate.
I say you are modest. You don't want to say that you led that committee. She led that committee. Now, previous annual reports about the performance of various superior courts as well as lower courts revealed that there were serious backlogs, and they continue to be serious backlogs in various courts. You are aware of this. Are you able to share with the Commission what causes these backlogs and what should be done to address them? And this is important, of course, because as Chief Justice, you will be, if you are appointed, the leader of the entire judiciary. Therefore, the performance of all courts is your concern. And if there are challenges, you ought to try and see what needs to be done.
Yes. It seemed to me, Chief Justice, that the real issue lies with case flow management. Where there were log jams, it's because other courts were running their operations in certain ways which did not yield the desired results, whereas those who abide by the case flow management system that is in place are able to get the desired results. That seemed to be the main issue in my assessment. So it seems to me that all heads of court must be urged, as they have been urged, to follow the models that actually work, the examples that actually work.
Well, there are other factors that have been mentioned as attributing to creating these backlogs, namely load shedding, namely judicial posts that are not filled for long periods of time because the executive has not approved the establishment of more posts or more judges or magistrates have not been appointed. And sometimes there are magistrates, there are judges, but there are not enough courtrooms. So it doesn't have to have a judge if you don't have a courtroom where he or she will sit to hear cases. And there have been situations where judges or magistrates, one has got to wait while another one is using a courtroom because there is a limited number of courtrooms. And then when that one is finished, then the other one can go in. There are also those challenges. Do you want to say something about that?
Thank you for that explanation, Chief Justice. Those are issues that fall under the umbrella I discussed during my vision presentation, which have everything to do with the capacitation of courts. Those issues fall there. The courts need to be capacitated in all those respects.
Now, the Constitution of South Africa, the Bill of Rights has got or includes or contains socio-economic rights. There have been some cases in the South Africa where courts have dealt with socio-economic rights and their enforceability. Would you like to share with the Commission what your view is of how that jurisprudence, how the courts are dealing with socio-economic rights, what the challenges are when they try to adjudicate those types of cases?
We have the grand norm, which is Grootboom. I don't know if you want to ask me specific questions, Chief Justice, on this issue.
No, I just want you to give an idea of how they are dealt with. Obviously, you might pinpoint to a particular case and say this is how courts dealt with this type of socio-economic rights, and maybe that's how all the others are dealt with. But I just wanted the Commission to have the benefit of your view when you look at that jurisprudence, how it is like.
Yes. The Constitutional Court in particular has done well in that regard, Chief Justice. And the test is the one that is found in Section 39 of the Constitution, how you deal with cases such as those.
I'm just checking whether you are done.
Yes, I'm done for now. I would really appreciate a specific question.
Oh, no. I just wanted an overview of how the jurisprudence goes. Okay, my last question. There is quite some difference between how reviews were dealt with to a certain extent before our constitutional democracy, that is under apartheid, and how they are dealt with, the powers of courts of review and our constitutional democracy. Would you like to share with the Commission to point out to some of the differences, to say, well, before our constitutional democracy, maybe these were some of the features or the grounds. Now, under our constitutional democracy, maybe it's easier to review or more difficult to review now because of this and that, and these are also some of the features of the powers of review of the courts.
Thank you, Chief Justice. I think under the constitutional dispensation, it is now easier to deal with that aspect of the law. We have Section 33 of the Constitution that deals with just administrative action, and you have the PAJA as the national legislation that provides for those situations. And that is how the courts deal with them.
Okay, thank you. Minister?
Yeah, thank you very much, CJ. I will firstly request your indulgence because I have some few questions.
You want to go to town?
No, I won't go to town, CJ. Good morning, DCJ.
Good morning, Minister.
Thank you.
You see, Jay, the minister looks like she is saying, I've been waiting for this opportunity.
Yeah, no, that's true.
I think he wants to hit back for the claim for institutional independence.
I heard the DCJ firing me from work. DCJ, my first question relates to the scheme of the Constitution. And from your presentation, and I appreciate, particularly with regards to the judicial-led court administration model, I appreciate that it's a policy-laden environment, which some of the issues, I believe we will engage with them as through the processes that are already established. But I'll just ask one or two questions in relation to that for the benefit of the public. One is that I do also acknowledge that from the executive it has taken long, but we are now ready to engage as we have already started the process on this matter. The scheme of the Constitution envisages a cooperative relationship between the three arms of the state, while recognizing the doctrine of the separation of powers. And from the executive side, we're expected to facilitate access to justice. how do you envisage the executive continuing to facilitate access to justice in a judicial-led court administration model?
I'm not entirely sure why the executive would not be able to assist if help was needed, Minister. For example, in the executive itself, if there is a department that needs assistance, I'm just trying to think of a concrete example where we had that the Department of Education, for example, asked for the transfer of certain rights, transfer of certain functions from the Department of Public Works to ensure that it carries out its mandate successfully, because the Department of Public Works was lacking in one form or another, and that transfer of functions was allowed. And I do not see why the OCJ would not be able to approach another department that it thought might be able to assist in one form or another where the need arose. The executive functions separately from the legislature. Well, the three arms function separately from one another. But we have had, for example, a case of a branch of the National Assembly, the Justice Portfolio Committee, for example, conducting a roadshow of the courts, which one would ordinarily assume to be a duty of the executive. They conducted a roadshow of which was a review of the status of the court system, the court, the status of the court infrastructure, among other things. And that exercise proved to be invaluable. So there will always be ways in which, at the end of the day, I think the focus should be that we are working towards one goal while we are separate. We are still working to serve the South Africans. So where there are areas where there can be cooperation, then help can be lent, if I can put it in simple terms.
Yeah, my second one relates to the budget issues that obviously have arisen from the presentation, in that, as you have said, in the judicial-led court administration, it will then be handled by yourselves. We account to Parliament for the budget and so forth. How do you envisage the judicial-led court administration accounting to Parliament with regards to the budget, and the fact that, as you are aware, the budget remains the prerogative of the National Treasury through the executive? How will you account to Parliament for this budget and these processes?
It seems to me that Parliament is the cradle of our society. It seems to me that that's where the judiciary should account as well. In the same way that the executive does, I don't see why the judiciary should do things differently.
Okay, I think I get it, that the Chief Justice will then be the one who goes to the National Assembly or to the Portfolio Committee to account for this budget.
Not necessarily the Chief Justice. The Secretary General of the Office of the Chief Justice will go to Parliament.
Yeah, we account through the executive. It's not the Director General, it's myself who goes and account. For Parliament is the Speaker as the as the other arm of the state, but maybe there could be some special measures, as you say, but maybe I will leave that for further engagement in another platform.
Well, if it must be the head of the institution, then the head must go and account to Parliament.
Okay, no, that's fine. So I'm taking this because in one of your earlier introduction, you raised the point that you have found it now very difficult that you are also administratively burdened when you in your first interaction with the CJ, that you also have to do judgments, your real court work, and also have to handle all this administrative work. Will this not further overburden the judiciary with a lot of administration work when you also have to run a department?
The Office of the Chief Justice is there to render the necessary support, and it will continue doing that with more powers now.
Yeah, my last question, DCJ, relates to also almost flowing from this, that it's a challenge which we have in government, with a shrinking budget for everyone, all state entities, government. There is a shrinking budget, and I'm aware that you are concerned as a judiciary that you are not consultant when this happened, and there's a process to deal with that. But my question is, how are we going to implement? How do we envisage implementing this vision in this environment of a shrinking budget for the fiscus?
There are departments that have been excluded from budget cuts, from example. We can't speak for them. We don't know what motivation they gave to be excluded from the budget cuts. The issue with us is that the Chief Justice was not consulted in this process. And the strange part now is that the judiciary is said to be excluded, but then the department that actually runs its operations is not excluded. All that the judiciary does is to adjudicate cases. The props for that operation are run by the Office of the Chief Justice. This tells me that if there was a will, as one must assume, to exclude the judiciary, then shrinking budget or not, money would have been found for the judiciary, just as it has been found for the other departments that have been excluded. For example, I think education is one of those.
Thank you very much, DCJ. Thank you, CJ.
Thank you. While I'm looking for hands, yes, I see one. May I take this opportunity to say, you know, in some jurisdictions, with regard to the question that the minister was posing to you about who would then account to Parliament, it's not a judge who will go to Parliament. It will be an official of an entity that, for example, in our present circumstances, you could call the OCJ, or there could be another entity which is controlled by the judiciary, and that the chief executive officer of that entity is the one then that goes to Parliament to avoid the idea that a judge should go and account to Parliament, because it's normally not taken as the right thing to do in terms of the independence of the judiciary. If it were to be done like that, is that something that you would be fine with?
Yes, Chief Justice.
Yes.
Yes.
Okay, all right. Thank you. Commissioner Marumuakhai?
Thank you very much.
I'm sorry, no. I'm skipping the president of the SCA first.
Thank you very much, Chief Justice. Good morning, DCJ.
Good morning, President.
Thank you very much for your comprehensive vision statement that you have shared with the Commission that gives valuable insight into the challenges that are facing the judiciary and how you intend addressing them. Just following up in regards to the issue pertaining to the capacitation of the Judicial Conduct Committee. You mentioned that an amendment to Section 8 of the Judicial Services Commission Act is underway in terms of increasing the number of members of the committee. My question is, once the number has been increased, and you also mentioned that more retired judges would be appointed on that committee. Would you be amenable to maybe using more or exclusively retired judges for purposes of the second committee of the JCC? You know, you correctly mentioned that the judiciary is overstretched because the workload has increased. Now, I know, because I have served in that committee, that in the appeal body, written decisions have to be given to the public. So it's as good as actually writing a judgment, which is a burden in itself. Would you be amenable to maybe asking only retired judges to participate in the appeal body, so that the time of the other members, because it's only senior members of the judiciary who serve in that committee, so that the time of these other members of other courts is freed for them to focus exclusively on the workload of their courts in terms of the writing of decisions. Would you be amenable to considering something like that, so that the sitting judges participate in the first committee, and then in the second committee, which is the appeal body, then only the retired judges should participate in that committee, so as to free the time of the judges the permanent judges, so that they can focus exclusively on the writing of judgments, not at the JCC, but only at their courts.
The committee is doing exactly that already, President. But as you know, disagreement may arise there too, and unfortunately, as things stand, not unfortunately, but we still have one sitting judge as a member in addition to me, and it does happen sometimes that disagreement arises, and more than one ruling must be given. So the sitting judge, as the component stands now, the composition stands now, will still have to write. But the hope is that in future, as you suggest, only retired judges are designated for these positions, so that we don't suffer the challenge that has been suffered previously. Sorry,
I'm saying at least for the appeal body.
Oh yes, certainly.
Yeah.
Uh-huh.
Okay, thank you. And the second aspect relates to the capacitation of the courts, which, as you correctly pointed out, is affecting the delivery of the courts, you know, in terms of the norms and standards. It's affecting the efficiencies of the course. So my plea to you, and I know, and you correctly identified as your short-term goal, my plea to you is that if by the time you are appointed, that problem has not yet been resolved, you should please elevate it so that it's no longer your short-term goal. It's something that should be done immediately to avoid the collapse of the judiciary, because as things stand, the judiciary is already suffering in terms of achieving its constitutional mandate and achieving the standards that it has set for itself in terms of the norms and standards, especially pertaining to the delivery of the judgments. I know that the Chief Justice has made overtures to the executive in terms of, resourcing of the courts. But my plea to you is that if that has not yet happened by the time you take over, could you please ensure that it's something that you attend to it on your first day of work as the Chief Justice of the country?
If I take over, President, I've heard you. I agree with you. I agree with the sentiment.
Thank you, DCJ. Thank you, Chief Justice.
Thank you, Judge President Lambo.
Thank you very much, Chief Justice. DCJ, good morning, good afternoon.
Good morning, Judge President.
I'm heartened when I listen to your vision as a head of court. I just want to follow up a little bit on what the minister asked you. There seems to be a fixation on the executive that whatever the judiciary wants to do, which is operational or budget related, must go through the executive. And I hear you strongly to say we can account on our own directly. Am I correct?
Yes.
You have our support in that regard. We also can think. And we are exposed to other models internationally where there are successful accountability models that the judiciary has embarked on. So you have our support in that regard. One issue that I thought I'll raise with you, and to following the lead by the president of the SCA, is the reputational damage or risk that attaches to the judiciary due to delayed judgments, one. Two, in Gauteng as we speak, there are people who are getting dates in 2027. And people can't wait that long for justice. But it's not because the judiciary is lazy or is not doing anything. It's capacity related. But it strikes me that something else can be done, and I want to check what your thinking is about this. If you look at Gauteng, it always ranks as the judge that has the most reserved judgments. And that speaks to the fact that its workload is higher than all other courts.
Yes.
The work that leads to reserved judgments, special motions in particular, these are the critical complex motions that come to Gauteng. Would it be something you would support for other divisions to avail periodically, and not longer than a week, a judge to be part of the teams that are allocated these types of work, for this work to be shared? If you look at opposed motions themselves in Gauteng, in Pretoria only, we have 340 per term. I doubt if there's a court that has more than 100 per term. So I'm saying burden sharing by the courts. Is this something you could support and try and encourage nationally? I know I'm ambushing you, but I look forward to your leadership and guidance, and that's why I'm putting this question to you.
I think this is one aspect we have talked about in the discussions we have had about our institution, and I wholly support the view you propound. I support it fully, and I would make sure that it happens in other divisions as well.
Thank you very much, DCJ. That's all, CJ. Thank you.
Thank you, JP. Commissioner Marumwahai.
Thank you very much, CJ. Good afternoon, DCJ.
Afternoon, Prof.
I do have two questions. The first one, perhaps, maybe comes from the discussion that you had with the CJ with respect to the quality of judges, the quality of judgment, or the view with respect thereto. I don't think it's a universal view, but there is a view that there are judgments that are concerning, and I think it's something that should be welcomed. On the basis of that, normally courts are structured in terms of the heads of those courts, the CJs. We hear things like the Charles Carlson Court, we hear the Lelanga Court, and other courts. And those courts are characterized in a certain way. The Charles Carlson Court was a sort of a transitional court. It was accepted in most instances, but the Langa Court was the most interesting. One of my colleagues defined it as a court that was responsible for several doctrinal innovations, including the expansion of the court's meaningful engagement with the approach of socio-economic rights. The question that I want to ask you is, what is, on the basis of that, how will the Maya Court be like? And then the question will be, what is your constitutional and jurisprudential vision of this court? And I'm asking you that because in your vision, you gave a structural challenges kind of vision. Perhaps you do not have a chance to look at the law and how your court will transcend going forward. So I just want to understand what would be the constitutional and jurisprudential vision of the Maya Court.
Well, I think the previous administrations is to steal a label from the executive have laid the right foundations, and in my assessment of the course of the course jurisprudence, even after their departure, that has continued, and I don't want to say anything about the I don't want to say alleged drop in quality, but I think the current court, the courts that have come, the Noble Court, the Muhweng Court, have continued on that trajectory. And I cannot imagine why, and the Zondo Court, I can't think why that would change with a new dispensation, if I may call it that.
I would have liked to see how you were thinking about the jurisprudence of the court, but let me ask my second question. You present a model of panels, and I kind of like understand it on this thing of applications and at that initial stage. I'm a little bit unease with the panels with regards to the hearing of matters, and this comes from what I have observed over the years in the Supreme Court of Appeal, where in matters such as prescription, competent verdicts, death benefits, accumulated retirement benefits, we are seeing the contradictory judgments that are coming from the same court. Are we not likely, should your model be approved and be accepted, are we not likely to see the Constitutional Court being extremely inconsistent on some of the most important issues that this court is now having to adjudicate? That is just my concern with regards to your proposal. Do you have any view on that?
that is a very fair question, Professor. There would be that kind of risk. And it's a risk that a court of this nature should avoid. But I'm just thinking of a matter we had very recently where we were all agreed that it did not, it should not have been set down for an open court hearing that could have been dealt with by way of a short judgment, which is another method that the court uses, where it determines that there is no need for an open for oral addresses. And invariably, cases that will not go to open court, obviously, are not matters of great national import. Although, if you still deal with them, even if by way of a short judgment, then you get all the full court always in, and you get that there is no chance of a divergent view arising in this one and another similar one that is heard by a different panel down the line. But I'm just thinking that even in situations where you have a full court adjudicating a matter, there is always a possibility of dissent. You will not get unanimity. And it is not far-fetched to imagine that down the line, that dissent may grow wings and legs and become a majority. It has happened, but that's a somewhat different scenario. What I'm trying to say is that in respect of cases that are not as important as others, they could be scope of using smaller panels just to ease the burden on everybody else. And in any event where the role has been prepared, even if you don't get to sit in that particular case where smaller panels are used, you get to know about the kind of cases that are going to be had during that particular time. And if an issue has arisen in the current role that has been determined before, it is not unusual for colleagues to talk about them. So those who go into the fresh hearing now would know what the court has already said on the issue previously. They may not follow it, of course. That has been known to happen. There is that risk. So you give me food for thought. It's a fair question, as I said.
CJ, sorry, CJ, if I can just follow up, that's my last.
Okay.
You raise another important issue, right? Where you are raising an issue of national importance or importance, and when you are crafting it, I'm thinking that we are creating another sort of system in law similar to exceptional circumstances, good cause shown. So now I then wonder as to how then will national importance be determined for the purposes of the constitutional court. Will this have to be something that is provided for in the constitution, or will it be provided for in the directives or even the rules of the court? Because if I take the matter to the constitutional court, as a litigant, I would think that matter is important to me. And national importance doesn't start from national importance; it starts from the citizens themselves. So how are we going to craft this national importance criteria that one has to meet to take the matter to the constitutional court?
That is not something that could be dealt with by way of a directive or even a statute. I think it would have to be provided for in the Constitution itself. So one would have to craft some form of some form of provision to cater for that. It is just a proposal, Prof, and as with any proposal, it would need to be debated, and you have people poke holes or support or until a perfect resolution is found.
Thank you, DCJ. Thank you very much, CJ.
Thank you. Commissioner Shabangu Mdawa.
Thank you, CJ. Good afternoon, DCJ.
Good afternoon, Commissioner.
Good to see you. DCJ, in 2022, when we interviewed you, you raised a concern regarding the lack of the sexual harassment policy within the judiciary. How far are we with the development of that policy? And is there a plan to protect the victims or the complainants?
Commissioner, she answered that question already.
Thank you, Chief Justice.
I asked her and she answered it. She said it has been submitted to me by the committee that she chairs and it's being finalized.
Okay, DCG, thank you for that. But can I proceed with this one? Is there a plan to protect the complainant from being victimized when they come forward with that complaint?
This is precisely what the policy is meant to address, Commissioner. And the unfortunate part is that it has taken, the Chief Justice, one of the first tasks that he undertook upon his appointment was to ask me to form a subcommittee that would prepare a policy, and that was done expeditiously. I think it was in March last year already. But it's a process, and for one reason or the other, it's not a decision that can be taken by the Chief Justice alone. It had to go to heads of court, and we're here now. It's still not been finalized.
Thank you, DCJ. But my second question then will be, you spoke about the outreach program, which is a good thing, I must say. But how are you intending to deal with this, taking into consideration the network, connection in the country, and as well as the workload of the judges?
It is not an undertaking that would be performed by the judges themselves, Commissioner. Remember, I said it's something I envisioned the communications department undertaking, a communications department that I proposed could possibly have a judge involved, a retired judge. I said a retired judge, perhaps, who would give direction on how this educational aspect of the education of the public, the public is something that's already provided for in the judiciary's communications policy. So it would just be carrying it through. And if you have a judge in the department, we create a position of a judge there, then it is that judge, with the assistance of the department, who would run that project. And they could do physical road shows if necessary, and make the necessary arrangements.
Thank you, CJ.
Thank you. Commissioner Singh.
Good afternoon, Commissioner.
discussion, and you have to put your foot down, if I may say so, DCJ. Because, I've been serving on a committee called a Standing Committee on the Office of the Auditor General for at least 15 to 20 years. Auditor General is the Chapter 9 institution. Auditor General operates independently, but is accountable for the finances to this committee called SCOAG. And SCOAG eventually reports to Parliament. Now, if we have the political will, we could also have a similar system where there is a committee which the Office of the Chief Justice reports to directly. And in the case of the Auditor General's office, it's not the AG that appears before us, but the DAG and officials related to finance. So I think where there's a will, there's a way, because, he who pays the piper calls the tune. And we cannot have the executive continuing to pay and calling the tune. I'm not saying they do so, but the perception can be that they do so. So the independence of the judiciary, both financially and operationally, is extremely, extremely important. And I would like, parliamentarians who get to Parliament next year and the next term and the executive to think about that method that's being used, that model that's being used. It's there, and we should use it. Now, the question I'd like to ask you, Honourable DCJ, is on section, I think it's 1744A. I mean, you are aware, and commissioners are aware, that we've had many problems with trying to fill vacancies in the Constitutional Court. And that is because that section of the Constitution says that there has to be 3 more than the person, that's required. Now, we've been talking about this for some time, and do you think that perhaps there is need to amend the Constitution, because there seems to be a reluctance for people to apply for the Constitutional Court, and you know as well as I do that we've had on many occasions we didn't have the required numbers to forward to the President. So that's my first question. The second question would relate to technology, using technology to ensure that the courts operate more efficiently and effectively. I think COVID was an eye-opener for us because it brought the hybrid systems into play. And is that something that we cannot use increasingly to expedite, so that, because say justice delayed is justice denied, to expedite, the time that it takes to deal with some of these matters? So that was my second question. I think the Chief Justice said 2 questions, so I'll just stop at that for now. But I'm really passionate about the independence and the suggestion that I made. Thank you, Chief Justice.
Thanks, Commissioner. I'll start with the easy one, the second question. During COVID, courts were able to work quite effectively and efficiently. Some even performed better than they did using the physical medium. But when things returned to normal, I suppose that's a common human quality to fall back into your old ways. There is just this hesitancy to use the virtual platform. I suppose the people are social animals. They want to interact physically, but we do not use that facility, which has advantages that everybody acknowledged, including the important one of access to justice, because more people, at least if you have access to the internet, can access court proceedings, and they cut down on costs. If your lawyers are not going to have to travel to a different town to present your case for you, then you don't have to worry about paying for the accommodation and travel expenses. But that is the challenge we have. But there's an underlying problem, a serious underlying problem to using technology as optimally as we could. The issues of connectivity, bandwidth. I don't have I'm not a techno geek. I don't have all the jargon. but bandwidth has been a problem. Uh, and in the judiciary, most courts, most if not all courts that have complained about connectivity always raise that. It was an issue even during COVID, but we had to make do with the situation. Unfortunately, it does not seem that much has been done to improve that situation. So that's something we definitely have to work on for the advantages that you point out it has. So that would be another task to add to the to-do list. Now about section 174 for A, that's a problem, an embarrassing problem that has been going on for quite some time now. But there's a view, there is a view in certain quarters that maybe not enough effort has been expended to building a pool. I would need to think more about that, to build a pool of people who have acted in the court long enough. Um, and uh, many colleagues who would actually, who are eminently suitable for the court, when approached, have refused to make themselves available because they say they have not been given an opportunity to act, so they're not going to waste their time. So maybe that's something that could be looked at. The SCA you had a number of good candidates only yesterday. The SCA does not struggle with attracting applicants to its court. And I think that's because, well, I know for there, I'm not saying it could work the same in the Constitutional Court. There is because the court gives a wide number of people acting opportunities, and you act, you are given a longish acting stint once it is seen that you have what it takes and you are interested in staying on. Most of the candidates that make themselves available ultimately for appointment to the Supreme Court of Appeal have acted there at least for 4 terms. Then you know that you are, you found your rhythm in the court. This is something you could really opt for. So as I say, maybe that's something that could be approached before we go to the radical step of amending the constitution. It's something to think about.
Thank you. Commissioner Nyambi?
Thank you.
Sorry, I couldn't press the comment on the independence.
Oh, sorry.
I'm
Oh,
sorry.
I'm sorry, Commissioner.
Singh,
Did I
you're
miss
not done.
something?
The comment on the independence and the standing
okay.
committee of Auditor General, like we have.
Oh,
chapter 9.
no. But sorry, I forgot to.
Oh, okay.
That was a very useful tutorial. I did not know that such a dispensation exists, and that actually could work. That model could actually work for the judiciary.
Yeah. Satisfied, Commissioner Singh?
No, thank you very much, Chief Justice.
Okay, all right. Commissioner Nyambi?
Thank you, Chief Justice. Afternoon, DCJ.
Good afternoon, Commissioner.
Happy to see you. We all agree that the dignity and integrity of the judiciary is a key component of the rule of law and it cannot be neglected. We'll also add that the integrity of the other 2 arms of the state, the legislature and the executive, is also very important. I'm also happy about how we have raised that issue in your earlier input. So, as a Chief Justice, you will head the judiciary. So, you'll be a leader of the judicial arm of the state. You are expected to be that link if you consider the other 2, the legislature and the executive. We have had some situations about some challenges sometimes What do you think is the best way or mechanism for these three arms of the state to work in a way that will avoid sometimes where any other leader of this arm of the state will take a public platform and deal with the other one?
Thanks for that question, Commissioner. As I understand it, there is already an existing structure, a tripartite structure in which the CJ and other leaders in the other in the other arms sit, where they they can they can discuss matters of mutual concern. I know that, for example, I think I mentioned that earlier in my vision, that the Chief Justice has requested a meeting, for example, with the president and other relevant stakeholders to discuss the issue of the adverse impact of budgetary cuts on the judiciary's operations. So that is a platform that can be used successfully. There is another structure that the Chief Justice established, comprising him, Minister Lamola, and I think the Minister of DPW, which deals with issues affecting matters that are relevant for those departments. So it is not an impossible thing to have structures with representation from the three arms, which do not impinge on the boundaries of the separation of powers, but just to advance matters of common interest. I don't know if that answers your question.
Yes, it does. My second last question, it's about the journey, your journey. When I greeted you, I said, happy to see you. It's because you are one of those that are fortunate in this commission. I remember as yesterday, the first time you came to be interviewed as the deputy president of the SCA, interviewed as president of SCA, interviewed as DCJ.
I've been
So-
here many times, Commissioner.
As we're about to make that historic milestone, I know you are a woman from a rural village in the Eastern Cape in Zone. Can you please give hope to a poor African child that where you are born is not an impediment to what you can achieve in life?
Yeah. You've touched the nerve, Commissioner. Yes. Well, to first, this current generation has social media platforms, so they are very savvy about what's going on around them. So they know of my existence, and the number of messages I receive from parents and guardians of young people who say, we had no idea that someone who comes from a dusty rural village such as mine, Kukwala, can ascend to such heights, and we are very encouraged, inspired by you. I speak to young people. I go to schools, especially in the townships and in the rural areas where you have children growing up in dire situations where there's no hope. And I have had successful interactions there, and you'll be surprised at what you get in those places. The brains, the thirst for knowledge and to be someone in life, even in the most squalid, the poorest of where you find our people. So I would just repeat now what I always say to those children, that all you need to do is to just uh, reach out for the sky, and chances are that you'll land somewhere in between the ground and up there, and that opportunities are there for anyone. Doesn't matter, your background doesn't define you. If you reach out for opportunities and you work hard, then you chances are you'll make it.
Thank you, DCJ. Thank you, CJ.
Thank you, Commissioner Traba.
Thank you, CJ. Good morning. Good afternoon, DCJ.
Good afternoon, Commissioner.
Thank you very much. In the questionnaire that this body asked you to complete, you write that you lost a year of study owing to political unrest at the university where you were a student, and that during that period, some students were expelled, and that one of the student activists, lost his life in the hands of the Transkeian police. You certainly would not have mentioned this incident if it did not have a significant impact on your life or prepared you for future role, possibly as a judge. Am I correct?
Yes, indeed.
Thank you. What are the key lessons you learned from that incident and how you have applied them to your role as a judge and or a leader of court?
Whew. And that's a sad reminder of a tragic time, Commissioner. Um, the lesson one drew from that experience was to stand for principle, for one thing, and the other is the constant reminder that what we have today came at a very high price. There are people who lost their lives for us to be here today. The student activist who was killed, you mentioned, was Batando Ndondo, who was our classmate, a young man who died even before he began his life, just for aspiring to, get freedom for his country. So the most important thing for me, and it's not something I apply to my leadership, but it's just a constant reminder that makes me appreciate what we have today, that the people who paid the ultimate price for what we have, because his death was not in vain, by the way. It did achieve something precious.
Thank you very much, DCJ.
Thank you.
So can I just next follow-up question, CJ? Yes.
Yeah.
And can you explain how you incorporate legislative intent and historical context into your interpretation of laws and the Constitution? And in the process of explaining, cite examples, one or two, where you have given effect to this philosophy. Thanks.
Well, in the interpretive exercise, Commissioner, the first thing to remember is that the Constitution permeates all aspects of the law. So you are guided by that principle initially. I'm not sure what you mean by historical legislative intent.
The historical legislative intent versus the historical context, because all the time there's context to any legislation that is being passed.
All right. Well, as I was saying, we are guided by the Constitution that embeds the values of this democratic dispensation we live in. So the Constitution in itself already has the context that you need in your interpretive exercise. So I don't want to. I'm anticipating what you are asking me, but there's only one way of interpreting legislation or a document, and that is there are ground rules for that. To look at the context, the ordinary meaning of the words, the context. I don't know if that's you want the legal answer.
And to contradict the past that we
I
come from.
suspected that's what you wanted to. I keep what happened in the past in mind, and that's why I say the values that are imbued in the Constitution already take care of that, which you must take into account when you do interpretation. They already have that context embedded in it.
Thank you, DCJ.
Thank you, Commissioner Kwaba. Commissioner Dodovu.
Thank you very much, CJ. Good afternoon.
Good afternoon, Commissioner.
Justice Maya. I carefully listened to you when you shared your vision. If you are appointed as our Chief Justice, and I did so 2 years ago when you were here, and there's only one thing that I'm missing or I don't understand it in precision. If you are appointed, you will be the chairperson of this body, the JSC, at least for the tenure of your office, which will be about 10 years. Now, this body, for a number of reasons, has been in the spotlight in the past years. What is your vision about this body? Its composition, for example, the work that it does, because I'll tell you why I'm asking you this. This body is an intersection of all the state, organs of state. Parliament, with all our diversity and all of that, different political parties, we are here. The legal professions, yeah. The judiciary yourselves are here. And the government, represented by the minister and the 4 representatives, we are diverse with all the contradictions that you can think about. What is your view about this body? There's been a lot of criticism about this body, whether we are combative or not, our approach, how we asking questions, how we do our job. In short, what will be your vision for this body so that it becomes effective?
Thanks, Commissioner. Look, we all know that there's been a complaint especially from the legal quarters for a long time that there are too many, I'll put it crudely, that is what has been said. There are too many politicians in the Judicial Service Commission. Maybe it would work better if it was limited to more lawyers, more judges, and various formulations have been suggested. But I don't share that view. I think this body, as you point out, is one of the most, if not the most, representative of our society in the country. It brings together all these various members of the various formations that represent our people. And I don't think the problem lies in its composition. It must be said, at the risk of antagonizing the commission, it must be said that the manner in which the commission has conducted itself on occasion has maybe been, things could have been done differently. It has not been ideal. But this body took a conscious decision to review its processes, the way it conducts judicial interviews, and issued criteria not so long ago, which it is abiding by, and the evidence is there for everybody to see. As a result, you don't really get any complaints about the way it conducts itself anymore. There will be an odd complaint where maybe a favorite candidate has not been recommended, but that's something else. The commission is abiding by the rules it set for itself. And if I recall, there was also at one meeting, an undertaking was made that it would continuously review its processes. And that to me shows a willingness to do things the proper way. If there is this, the body realizes the need to, even though things seem to be all right now, but it recognizes the need to continuously look at itself to check if it is still conducting itself as it should. So in sum, I don't have a problem with the commission as it stands, its composition, and I think as long as it abides by the criteria it has committed to itself, then there's no need to change anything. You don't change what is not broken. You don't fix it.
CJ, in the interest of time, I'm okay. Safe to say, this job is nip up and placed.
I guess you sympathize with me. Thank you, Commissioner Moimang.
Thank you, Chief Justice. Good afternoon, Deputy Chief Justice.
Good afternoon, Commissioner.
Just one question from my side. One of the case that you have listed on your contribution to jurisprudence is the matter that involved the public protectors in an instance where the suspension by the president was set aside by High Court. Then the second aspect of that dealt with the suspension of a court order pending appeal.
That is the DA against.
That is correct,
okay.
DCJ. If the DCJ can just illustrate as to why is this case important in terms of its contribution to the jurisprudence. The second point related to
Sorry,
that.
I didn't catch the question. Why?
Why is the DCJs of the view that it is important? It has listed it as.
Why have I listed it
as an important case in terms of your contribution to the jurisprudence?
All right. I have written only 3 judgments at the Constitutional Court, so I just thought, well, let me not say that, but I've only written 3 judgments, and I listed all of them just to show the commission the work I have produced while I was there. That was the reason. There are many judgments I've written, many judgments I've written as a single judge, and at the Labour Court and at the Supreme Court of Appeal, which I consider quite important. I've written judgments on various aspects of the law. For example, in tax, I've written in maritime law, but I've not listed them here, because I don't consider them to be, they are not. I consider them to be just black letter law, and if you notice, you just check the other judgments I've I've listed, it's judgments that concern the rights of people, mostly about rape and cases involving Esther, Pi, the rights of farm workers and labor tenants and so on. So it is certainly not my best product. As I said, I just decided to list all the cases the judgments I've written in that court to show that at least I've written something.
This is the second aspect thereof also. You draw a distinction between, because there were two questions, you draw a distinction between the two in terms of cost orders. In relation to the first one, there is no postal cost orders granted granted in person. But in the second one, there is an order in relation to personal costing, personal capacity. So I also want to invite the DCJ probably just to elaborate on why the distinction.
All right. Well,
Thank you.
the reasons are stated there in the judgment. The personal cost order, which I suppose is the controversial one, had to be made because the public protector, the office of the public protector, had deposed to an affidavit which distanced itself from that litigation, and it had made a provision to cover the former public protector's costs in the dispute, but not for this particular for this particular. Remember, there were three matters in one in that case. In this one, they said they had not given the mandate. They had not given any undertaking to meet her fees, and we found, as I recall, we found that that application was not necessary in any event because the matter was already before the Constitutional Court was going to be heard, so it did not need to be launched at all, and someone had to bear the costs, and it could only be the public protector. But that was only in respect of one matter where there was no offer of a contribution by the public protector to meet her fees.
Thanks, DCJ. Thank you, Chief Justice.
Thank you. I only have 5 more names, and I propose that I don't add to those. Commissioner Makwanisha?
Sorry, CJ, as I was answering Commissioner Singh's questions, I saw that Commissioner Lucas had a hand up already.
She is the next one after
All right,
Commissioner
you have
Makwanisha.
her. Okay.
Yes.
No, thank you very much, Chief Justice. Good afternoon, Deputy Chief Justice.
Good afternoon, Commissioner.
No, let me start by appreciating the good working relationship in managing the transition between the Chief Justice and yourself. I think it's a very good way of managing a transition. I think it should be appreciated. It's also good for an organization like the judiciary to have that good working relationship. I only have 2 clarity-seeking questions, short ones. One, what is your view, Deputy Chief Justice, in the alignment of terms of offices of the Concord and other courts? Remember, in the High Court and Supreme Court of Appeal, you retire at 70. And in the Constitutional Court, it has got a term limit of 12 years. What is your view on that? Should we have all the courts having the same term, or is the current position still a good one?
I know that there's been a concern that the Constitutional Court term costs the fiscus money because you have these judges who work only for a short time, and some had retired at very young ages and they go on and do other things. And you need to keep the the skills and experience in the judiciary as long as you can. My answer, Commissioner, would be that there was motivation for the decision to keep Constitutional Court judges for that limited period. And other than what I'm raising now, the financial concern, I have not heard another compelling reason why the current dispensation should be changed. I'm not saying the financial consideration, especially as the country is in dire financial straits. I'm not saying it's not important, but it seems to me that to tamper with an arrangement of this nature would need more than a financial concern. I doubt you'll be happy with my answer, but that's my honest feeling about it.
No, no, just seeking it was a clarity-seeking question. Maybe
Your voice is quite soft,
Soft.
Commissioner. I'm not sure that everybody can hear you.
Oh, no, I was saying that, Chief Justice, no, I'm fine with the answer. It was just a clarity-seeking question. And then the second one, Deputy Chief Justice, it relates to the issue of salaries.
Salaries.
Yes. The issue you raised earlier on. You remember there was a report in 2008 which developed a principle of parity of arms. And as a result of that report, the salary of the Chief Justice was paired to the salary of the Deputy President, the Speaker of the National Assembly, and the Chairperson of the NCOP. Now, you were saying that you should move away from the remuneration of public office bearers determining the salaries. So, are you suggesting that we should move away from that parity of arms and have a new, different dispensation for the judiciary?
I'm just trying to find a tactful way of saying this. Let me say no, Commissioner. I am not proposing a different dispensation as speaking for myself, but there are representations that have been made by the judiciary to the IRC, which have not been given adequate, which have not been given a hearing at all. It's a detailed dispensation. Right now, the judiciary is still in talks with the remuneration committee. They must have a meeting, which has not yet happened, and I'm just hesitant to discuss the contents of that while it is still work in progress.
Thank you very much, Chief Justice. Thank you, TCJ.
Thank you. Commissioner Lucas.
Thank you very much, Chief Justice, and good afternoon to everyone. I really miss you, TCJ, and I think this is really, it's really very, very good to see you sitting here once again. I told you once that you are a trendsetter, and I told you once that you have broke the glass ceiling for many women, and I think Honorable Nyambi actually covered that, but also on my introduction that I really wanted to bring, Honorable Marwanishe covered that, and that is the fact that the maturity that exists in the relationship between yourself and the Chief Justice, particularly with the transitional phase. So I think we have really came a long way as this body in terms of making sure that we address the issues of parity and equality But in your view, how will you say you measure the progress that we have made with ensuring that we promote not only the appointment of women, but bringing about equality in the judiciary? I actually also want to add that I'm very pleased to hear that Lekgotla eventually took place, where there is at least a kind of a semblance of uniformity, and also a kind of a semblance of a better working relationship throughout, and also en route to actually building one single judiciary where people doesn't feel that they are excluded, and where magistrate doesn't feel that there is not enough is being done to make sure that they feel part and parcel of judiciary. I also want to commend the fact that when appointed, you actually have you actually want to, in your own operations, make sure that you actually acquaint yourself with the courts in the country, because I realized that people will never feel important if you doesn't make them feel important, and they will feel very important if really their head, as you will be visiting them and making sure that you encourage them, so that also the image of judiciary begin to become, particularly in the eyes of South Africans, that sometimes can be so negative, or like what we are experiencing. We have been experiencing power outages for many years, but since load shedding, if the power just go out, people say load shedding again, load shedding again. So what I'm saying is that we've got a populace that are very challenging and sometimes very negative. So we need also to encourage those that are serving the people. And with that, you will really play a very good part. But my question, and I think maybe I must ask both so that I don't come back, is that how do you measure the progress that we have made with promoting equality, not only in the appointment of women to the judiciary and particularly to judicial positions, but also the issue of other groups, target groups that is there, like disability and so on. And secondly, you spoke about the financial challenges that you experience, particularly with regards to issues of training and development. And our experience have been that, particularly the magistracy, and I will mention just these two factors, the issue of on dealing with gender-based violence, but also the issue of dealing with issues of customary law. There is still challenges that we experience, particularly at the level of the magistracy. So in your view, how do you measure this, and what do you think you can do more to make sure that, particularly in training and development, but also in addressing the whole issue to promote equality? What more can be done, and how will your approach be? Thank you very much. And let me just conclude by saying, I wish you all the best. And we are very proud to be associated with you as a woman that have been making great strides in making sure that other women is also being empowered. Thank you.
Thank you, Commissioner. I'm going to answer the first question and then ask you to remind me of the second one. I didn't quite catch it. How do I measure the progress that has been achieved regarding, and I'm paraphrasing, regarding gender diversity in the judiciary? Is that a correct summary?
Exactly, but also adding on the issue of targeted groups like people with disabilities and so on.
All right.
Yes.
Thank you very much for that question, Commissioner. Significant progress has been made, but it's still not enough, as I said. Today we have a sprinkling of women judges in the leadership structures of the judiciary. I mean, we have President Molemela and two judges president, hopefully another one soon at the Lanes Court. the candidate that was recommended by this commission recently for judge presidency of the Land Claims Court. So that is significant progress, and more you look at the demographics as provided by this body of how many women judges there have been, and the numbers are still not enough. The magistracy has done very well in this regard as well. They actually have more women than men in that rank of the judiciary. Many of the women that are either in leadership in the superior courts or are in the courts, in the superior courts, come from this program that was just resuscitated, the Bridget Mabandla Aspirant Women Judges Program. Those, most if not all the candidates of that initial program that was conducted many years ago were absorbed into the judiciary and have made their way up the ranks and are senior judges today. And that tells us that giving women a chance, offering them training and development, setting up these training and development programs actually works. And this is what is hoped the program in its revamped form will achieve. And in fact, the first crop of graduates from last year, we had, I forget now how many there were, but 19 of them were invited to act in the High Court. So chances are that most of them, most if not all of them, will become judges. So this concept works. And I don't think we have to do anything fancy. What you do is to source potential candidates. You look for people who promise to have what it takes, and you give them a chance. Either you train them or you invite them to act, as most women judges, have come into this sphere. They were given acting appointments from practice, from academia, and were absorbed. But we need to intensify that. All we need to do is to intensify that effort. Just intensify it, and it works. And the same applies to people with disabilities. Give those people a chance. We have a judge with a disability, Judge Munzelele, who by all accounts is doing well. She's doing as well as other colleagues. Her disability is not, that does not impede her execution of her judicial duties. So you just have faith, and if people have a potential, or if they've shown they have the merit to be given a chance, you give them the chance, and that's how you build a pool. I don't have a fancy answer for you, but that's what I've seen work. So that's what I would continue to agitate for, that you continue doing. And you have associations such as the South African Chapter of Women Judges, which conducts its own training for women and employs various measures to get women starting from young students who are mentored by judges and magistrates who are members of that association. Those people are likely to end up here in future. And you have SAULA, which is led by Commissioner Shabangu Mdawe, which does the same thing. So you just need to encourage, intensify the efforts that are already in place. They work. Just pour more energy into them, and you'll get the pool you need, and you'll get the numbers of women, competent women you need in the judiciary. Then the second one, all I had was challenges of relating to GBV and customary law cases in the magistrates court. What about those?
Thank you very much. Thank you, CJ. And I just want to say I like practical responses, and you were very practical in your responses, and I like that. the one on the magistracy. In fact, you spoke about the issue of challenges with your budget on training. And most of the issues that we have experienced in our in our consultation process was the lack of really sufficient knowledge at the level of magistracy on issues of gender-based violence and customary law in particular. So what I'm asking is that how innovative you can be to make sure that training and development at that level is being enhanced.
Well, we use the existing structure, the SAJ commissioner. We train, and train using the SAJ.
I assume that answer is complete.
It is complete, Chief Justice.
Okay, all right. Commissioner Baloyi?
Thank you, CJ. Good afternoon, DCJ.
Good afternoon, Commissioner.
Yes, the first of my two questions, the first one is picking up from an earlier discussion that you had with the minister, and it is about if you achieved the independence, the administrative and budget independence that you seek or that you're proposing, how do you account for that? Now, I think in the discussion you clarified the position, I think, that you would have a mechanism through which you account to Parliament. But the first response of that, in the engagement, that the head of the judiciary would therefore would have to account to Parliament. At first blush, it would raise concerns about your views about the breadth and the depth of separation of powers, of the concept of separation of powers. And perhaps we should hear, I know eventually it gets resolved because you say, well, there will be a mechanism because other jurisdictions have mechanisms, but to the extent that that response implicates your own jurisprudential position of views about the separation of powers as a concept. Can you just speak more to that so that if there are any concerns about the Maya Chief Justice period being problematic when it comes to separation of powers, that can be cleared?
Well, this question arises only now that there is this quest for a totally independent judiciary commissioner. Until 2013, the entire judiciary, judges and magistrates, had their affairs run by the executive, the Department of Justice. And the question of, I remember when I was at the SCA, the president of that court, Justice Howie, would rush to Parliament with two other senior colleagues, perhaps to go and account for one thing or the other. This question of separation of powers, this concern was never raised. So I am not entirely sure. I don't see how it is offended if judges are actually, let me just preface this with the suggestion that was made by Commissioner Singh, by the way, on this committee that could be set up to address this, I think would be a perfect answer, take away any concerns there might be around that issue. But what I was saying is, I'm not sure why it would suddenly be a concern now that judges are actually running their affairs themselves and they go and give an explanation there, an explanation to the South African public, when previously they were in the clutches of the executive. They were given everything by the executive. The executive literally ran their lives. And the concern, which is the main thing that led to this proposal that we have this model, was that judges always had to go with cap in hand begging the executive for this, that, or the other. And sometimes they didn't even have the opportunity to beg. They were just given, and they had to take that. So I don't think there's a real problem there. I really don't think so.
Yes. The second question is about, I think when you set out your vision, I agree when you say that as a judge, well, firstly, your first job is to adjudicate matters. And when you sit there, your vote is not any weightier than any one of your colleagues. I guess no one can argue differently about that. And yet there is the expectation that as Chief Justice and therefore head of the apex court, the court that finally pronounces on questions of law, you would, there's an expectation, and you can say if it's an unfair expectation, that you would be the intellectual leader of that court. And so should there be or should there not be a fair expectation that you would provide leadership as the number one or as the expected intellectual leader of the court? If you agree with that putting that burden on the office of on the Chief Justice, how practically in the period that you're Chief Justice would you go about realizing that goal of providing leadership, intellectual leadership?
It is not an unfair expectation, Commissioner. The reality of being a head of court is that you lead from the front in all aspects of your job. And you do that by sitting in court with the other colleagues and giving your input. I repeat that all judges, whether it's the Chief Justice is not going to persuade a colleague to go a certain way to agree with him simply because he's a Chief Justice. You persuade one another in the panel by presenting your reasoning, the way you view the issues and how the law should apply to those issues convincingly, which is counsel's duty, by the way, counsel having already laid the foundations in court. And I want to think that I've been able to do that. I'm trying to remember a case, for example, when I was at the SCA, where a colleague dissented in a matter in which I wrote, for example, and I can't think of one. So I want to think that there would not be a lag, I'm looking for the right English word. I don't think that there would be, it could be said that leadership was not provided in that regard. Whatever interpretation you want to give to the term leadership. But I just want to stress that when you have had a case, what position each judge holds in the court is irrelevant. It's how you view the case, and if you can persuade your colleagues to go along with you, then that's that. On that.
Thank you, DCJ. Thank you, CJ.
Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, DCJ.
Good afternoon, Commissioner.
DCJ, I just want to pick up on this question of full institutional independence that you've been dealing with in the course of the morning. Now, we know that the Office of the Chief Justice was created through a determination made by the Minister of Public, in terms of the Public Services Act. So there's no bespoke legislation in place which creates the OCJ and regulates its functioning. Do you think that that's a satisfactory state of affairs to give effect to full independence? Or do you think that it's necessary to have a bespoke piece of legislation dealing with it?
That is another area of concern for the judiciary, that you have an SG who is, for all intents and purposes, an employee of the public service PSC, what do you call it these days? But it's a PSC official. This model we clamor for calls for a bespoke head of administration for our department.
And that would require bespoke legislation?
Yes.
And just then the second question, tying on to something that was raised by Commissioner Nyambi. Now, in paragraph 18 of your questionnaire, DCJ, you say that, and I'm just quoting what you said in your questionnaire because I found it quite profound. You say, I believe that my experiences as a Black woman from a rural background have provided the judiciary with a critical diversity of thought and valuable insights into a complex, vulnerable, and huge component of our society. Can I just ask you to just explain that a bit further, DCJ, and tell us specifically your experience as a Black woman coming from a rural background? How does that affect your judicial philosophy and also your leadership of the judiciary as a whole?
Thanks for that question, Commissioner. Diversity in the judiciary is a requirement precisely because of the different insights and perspectives each judicial officer brings to the job. That's why you need to have women, men, and there's the race component as well. And you break that down even further. It is important to have people coming from, the different sectors of our society, representing them there. For one thing, it engenders public confidence in this institution. For a woman, say, to see another woman sitting there adjudicating their case. It engenders public confidence in people coming from a rural background to know that there is someone who comes from their environment, who understands their needs and aspirations, sitting there deciding their issues. That's one part of it. And I don't know what more to say, but that's the effect. That's the importance, the important factor about having diversity in this institution. You pull in people with all these different experiences and insights, and they bring that into their judging.
Thank you, DCJ. Thank you, CJ.
Thank you. Commissioner Mangena.
Thank you, Chief Justice. Good afternoon, DCJ.
Good afternoon, Commissioner.
I too am filled with hope. Yesterday, we were told that the Supreme Court of Appeal has more women judges than male judges, but it also has more Black judges than of other races. And truth be told, that is as a result of your intervention since you took over the leadership of that institution. And I want to say to you that this is a proud moment for our country. Brick by brick, the country is dismantling the apartheid legal order. And in less than 50 years, or less in 30 years of democracy, the country has been able to do what other people could not be able to do in many years, the production of a woman chief justice. And you've got to be proud of yourself. But then, yesterday we were also told about loss of expertise, more especially at the SCA. And it brought a question to me as a person sitting here in the JSC, that as people are leaving due to natural attrition, others should be coming. And I think that is where SAJE comes in, and the Act says that you are the chairperson of SAJE. In your vision, do you see a situation wherein there would be a proper program developed for the training of judges? Something similar to National School of Government, where there would just be a program, people interested in becoming judges go and enroll, and after obtaining the necessary qualifications, they may then be considered by this body.
Okay, first, thanks for the compliment. I just want to clarify that the credit is not entirely mine. The efforts to diversify the SA started even before my time, when the two women I found there were invited to the court and ultimately got appointed there. And then I came in. So the head of court who invited me actually is part of this process, and that was President Howie. And then Judge Mpati also did his bit. I only intensified what had already started. But thank you. And now about the loss of skill. You mentioned Sajay, and that is exactly where it fits in. But it is not enough. I recall that when I was at the SA, I don't know if, that project, in fact, fizzled out even before I left. We had started, well, not started because it's something that had happened, but infrequently. We had a peer training mechanism where we would invite colleagues still in the court to, I mean, you had people with various wide experience in various areas of the law, either still as sitting judges there or retired. I remember the person who started this, we saw this from, was Justice Harams, who is an intellectual property law expert, and he used to have afternoon sessions with us, just going over recent developments in the law, and which were very useful. So we built on that, and we would call other judges, now retired judges from that court, to come and talk to us about judgment writing and various other aspects of our work. And everybody who participated in that exercise found it very, very useful. I mean, there are other creative ways we could employ to beef up the SAJE. I'm not quite sure how far to take this, but the reality that we need to accept, Commissioner, is that Black lawyers were excluded from these areas, the commercial work, these areas of the law, which are somewhat suffering now because you have more black judges coming in. That is the reality of our situation, and it's not the black judges' fault. They started on the back foot, and that is the reality of our past, and we have to contend with that. And I think I've said in this body before that the chickies of Bantu education and everything that was done to black people have to roast somewhere at some time, and we can't wait for the next generation. We can't wait for the commissioner, the commissioner Ngai Tobis and the others who are excelling, Commissioner Nokesi, because we know that they are very competent and able black lawyers today because they've had opportunities maybe my generation did not have. We can't wait until those people are ready to come to the bench. We need to diversify the bench now, and we look for people with potential, but those people need help. So and that's part of how I feel about what you've raised.
Thank you, DCJ. Thank you, Chief Justice.
Thank you. That was the last commissioner to ask questions. I just want to return briefly, DCJ, to the issue that arose from one of the minister's questions, and that both Commissioner Baloyi and Commissioner Pillay also asked about. We might not need to discuss much further about it, but I think that at least for me, the problem about a judge or chief justice going to parliament to account, as the executive ministers have been doing, is that one, in terms of the executive, you have specific provisions in the Constitution that require the ministers to report to Parliament. And there are no such provisions relating to the judiciary. But of course, when you talk about funds, taxpayers' money, you can't have a situation where there's going to be no accounting. At the moment, the accounting is done by the executive because that's the current arrangement. But one would prefer an arrangement in terms of which we keep our independence as much as possible and go for a model which doesn't require the Chief Justice or a judge to go and account to Parliament. And the model of an entity or organization which is controlled by the judiciary, which might have a chief executive who does that, certainly appeals to me. And the model of the Auditor General is also one that appeals to me. So it avoids that situation that we are trying to move away from. But I have no doubt that having heard of the Auditor General kind of model, which you support, that's the one as Chief Justice, if you are appointed, that's the kind of model I think you would be pushing for. Am I right?
Yes, Chief Justice.
Yes. Right.
Chief Justice, can I just ask, this model of the Auditor General?
Yeah.
My understanding is that it's the Deputy Auditor General who accounts to Parliament. So how is this going to work now with the judiciary?
Well, I didn't understand that it's the Deputy General, Auditor General, but maybe it is. I understood that it's some official. But in terms of the entity that I am talking about, it would be an official and not a judge in terms of the judiciary. It would be an organization such as the OCJ, where you have an administrator.
Should we not just leave this open
Yeah.
for further consideration? Because if we leave it.
No, it's not. It's not final. It's ongoing discussions between us. Yeah, it's ongoing discussion. You know. I know what he's pushing for, and you may have heard. You may have heard what the JP this side said. He wants to continue to report on behalf of the judiciary. Okay, I think we've come to the end of this interview. DCJ, thank you very much for coming to this interview. Thank you very much for availing yourself. I think now you are excused.
Thank you, Chief Justice. May I just thank my colleagues. Well, first, the president for nominating me, regardless of what happens ultimately, but just giving me the opportunity. This commission for giving me this opportunity, and my colleagues and everybody else who has supported me for their support. I think that that's the African thing to do. I'd like to thank them very much.
Thank you very much.